No, Crowley's doing all that. They're not gonna want to see the reports again after Crowley. Crowley's gonna hit that hard.
first I'm going to go over some insurance terms so that the jury understands exactly what you and I are talking about as my questioning goes on. But first I want to go over the title that you described that you had at the time of the adjustment of this loss. You were a large loss property damage claims adjuster?
Well, my official title is General Adjuster, but I work for the Major Case Division of Travelers.
Okay. Did you primarily do property damage claims?
Exclusively property, yes.
Were they exclusively first-party property damage claims?
Well, you know, we insure the owners of the property, whatever property is being claimed for.
Right.
So yes, you would, I guess you could call them first party strictly.
Okay. We're going to get to the definitions of first-party and third-party in a minute. But the claims process involves you performing investigations, communicating with individuals, communicating with people that have relevant information regarding the claim, and then putting a summary of that activity into your claims notes. Is that right?
That's true.
And so if there is somebody else involved at Travelers who wants to assess what or where the status of the claim is, that person can access your claims notes and see where the claim sort of is progressing. Is that fair?
That's true.
And you have supervisors that you report to?
Yes, sir, I do.
Okay, and those supervisors could get access to your claims notes to determine what actions you've taken, where the claim was, and what actions maybe you should take?
Yes,
Okay, that's the purpose of the claims notes?
yes.
Okay, so let's talk about first-party claims as opposed to third-party claims. A first-party claim that you would get involved in would be a property damage claim reported by a policyholder of Travelers, right?
True.
Okay. And what you would do when you got that report is you would determine whether or not the person doing the reporting actually has a policy issued by Travelers, right?
True.
And you would do things like determine whether the accident in question occurred during the policy period,
True.
meaning there was coverage at that time.
Yes.
The policy was all paid up, the premiums were paid at the time. You do all that.
Yes.
And then you would determine the nature and extent of the damages, right?
Yes.
And you would determine whether those types of damages fall within the coverage agreement, the policy agreement, right?
Yes.
And then you would also determine whether or not there were any exclusions which might exclude the damage claim from the policy. You would do that too?
Yes.
Okay, all right. So let me talk about, let's say, a garden variety first-party property damage claim. Not necessarily a large, complicated loss like this, but let's talk about something like when my son took my car and backed it into a light pole in the city of Menor and knocked it over. I have insurance through an insurance company, so I reported that to my insurance company because of the damage to my car. Would you agree with me that's what we call a first-party property damage claim?
That's true.
Okay.
Yes.
So I would deal with, I would be contacted by a property damage adjuster from that company, similar to you with Travelers.
Yes.
And that person would do, as you did in this case, determine what my coverage was, whether it fell within the policy period or the types of damages was covered under the policy and whether there was any exclusions, right?
Yes.
Would it be good practice for that particular adjuster, in your experience, to also make a determination as to whether there's any other available insurance which might be covering the same claim?
Yes, we always try to look if there's other insurance covering the same property.
For
Yes.
example, in my scenario I described, if my son had his own auto insurance, but he was driving my car, that would be something that adjuster should investigate. Is that fair?
Yes.
Okay. He should not ignore that, right? He
True.
should not fail to assess whether or not there's other available insurance. I guess that's what we call it in the insurance world, other available insurance, right?
True. Yes.
Okay. You would be critical of a first-party property damage claim adjuster if they did not look to see if there was any other available insurance, would you not?
I would think so, yes.
If you were supervising somebody like that, let's say.
True.
Okay. Now let's talk about third-party claims. You're not, or at least at the present time, and I understand you're close to retirement. Did I hear that correctly?
Yes.
Am I right about that? Okay,
Yes.
congratulations.
Thank you.
I'm jealous. At Travelers, were you ever involved in the third-party claims department? Is it a different department?
Well, third-party claims would be, I would think, liability claims typically. And I have not, in my career, I've worked liability claims many, many years ago, but I haven't worked a liability claim in probably 30-plus years.
Okay.
Yes.
So let's describe for the jury what a third-party claim is. A third-party claim, and let's use my analogy with my son. This is what we have, this is the burden we have to all bear with this, with a young son. So the city, of course, has a broken light pole and made it their business to contact me because they wanted to hold me and my son responsible for the repair of that light pole. So they're a third party making a claim against me, the city, right?
Yes.
That's a typical kind of a third party liability claim
Yes.
in that scenario. So that's what we have here in this case, right? This is a third-party claim against American Fireworks Company. Is that more or less correct?
That is my understanding,
Okay.
yes.
Travelers in the school district are making a third-party claim against American Fireworks to recover the damages they paid for the roof repair, correct?
Yes.
Okay. All right. So, during your involvement with investigating this claim, I noted that you didn't make any contact with American Fireworks Company to inquire as to the circumstances of the fireworks display, how that fireworks display was shot off, and whether it complied or didn't comply with state or federal regulations governing that. You did not yourself.
No, I did not.
Okay. Now, you're to be excused, really, because you're in a first-party property damage scenario where your job is to assess whether or not this damage claim falls within the policy and then determine what is to be done with that claim, whether it's repaired or replaced and what the cost of that would be, right?
True.
Okay, so you're not really concerned about how the damage occurred, you just are concerned about whether the damage is covered. Is that right?
The damage to our property that we insure, yes, we need to make sure that that is a covered peril that damaged that property.
Okay, so when I say you didn't contact American Fireworks, it really wasn't within the scope of what you do, right?
No.
Right.
True.
Okay. Is that true?
Yes.
Okay. And you didn't contact the city of Willoughby, you didn't talk to Captain Kokab or anybody about the fireworks display because that's sort of not really what your scope of what you were involved in. Is that fair?
Yes, true.
Okay. Let's look at the claims notes. You weren't the first Travelers adjuster to become involved in the investigation of this claim, right?
Yes.
There was a Jason Carper, right? He was the first on-the-scene Travelers claims adjuster on this loss. Is that fair?
Yes.
Okay. Can we have I, please? The confirmed. Can you tell me what we're looking at, Mr. Ellis?
It looks as if Jason has made notes regarding his findings at his inspection.
Well, let me be more general. What is this document?
This document is a claim file note.
Okay.
Yes.
Like we talked about, that adjusters will enter into the activity that they're doing with respect to adjusting the claim, fair?
Yes.
Okay. So that somebody who's looking at the claim, above Jason, Travelers could see what happened and what he did.
Yes.
Okay. So Jason apparently attended an inspection on August 20th, 2019, and he writes the following note: confirmed marring and burns present on the rubber roof, sporadic and throughout the building structure. The parties and the manufacturer argued over repair versus replace and the warranty of the roof, as the roof was just completed within months of the DOL, which is date of loss, right?
Yes.
Okay. Did I read that correctly?
Yes.
Okay. So, okay, take it back. Keep it, okay. Down at the bottom, it says, I'm sorry. This is the only note that I found that Jason Carper entered into this loss file. Is that right?
Well, I don't know how many notes. I don't have my computer in front of me. I could find out, but yes, if that's the only note you could find, I'm sure that's all he entered.
Okay.
Yes.
Above that, you see where it says reviewed file? Steve? Yes. it says reviewed file that has been reassigned to MCU. What's MCU?
Major case unit,
Okay, is that your unit?
yes.
Okay. Reviewed with MCU. Is that you?
The review would have been done with one of our sort of, I guess we have dispatchers in Hartford who
Okay.
decide whether to accept these files, and that probably would have been done with them.
Okay.
Yeah.
And it says closing task referral. What does that mean?
That means that he is done with his adjustment of the claim, and now he's going to pass it off to MCU to handle the rest of the time.
And when it got to MCU, it was assigned to you?
Yes, it was.
Okay. Did you review Jason's note when you first got the loss?
Yes, I did.
Okay, let's go back to that note. So you would have read the note that said, parties and manufacturer argued over repair versus replacement and warranty of the roof, as the roof was just completed within months of the DOL. You would have seen that note.
Yes,
And it appears, based on the fact that you're here and I'm here and the jury's here, that we're still arguing over repair versus replacement and the warranty of the roof. Doesn't that appear what's going on?
yes, it does.
Okay, all right, so let's look at Exhibit JJ. Can we go to the last page? Exhibit JJ, Mr. Ellis, is that, what I've been told are your claims notes on this loss from start to finish.
Okay.
Do you have any reason to disagree with that?
I do not.
Okay. It looks like your first loss, your note to the file was on August 21st, 2019, where it says, I received the MCU assignment 8/2019. So that's the handoff from Jason Carper to MCU, and then it got assigned to you.
Yes,
Okay, all right. It said called insured, contact Steve Johnson on 8/20, okay? And then the next note above that is August 24th, 2019. It says, I inspected the risk with Kent Hansen.
yes,
So that's the note that covers what your testimony was in response to Mr. May's questions, where you described what you did, looked at the pictures, described your experience being out there on the scene.
yes.
Okay, all right. And then, let's page through your notes. Go forward, let's go to the page just immediately before this one, up at the top. See that JM? Okay, so this is a note dated, well, let me see. I can't tell what date this note is. How would I find that out? Can you tell what date that note is? Oh, wait, you went all the way to the beginning. Oh, I'm sorry. Yes, you're right. Okay. 9/11 down at the bottom. This is a note dated September 11th, 2019. Can you go to that second page of that? Yeah, go to the next page. Up at the top, JM. This is a note that you entered into September 11th, 2019. Up at the top where it says JM. I'll read the note, you let me know if I'm reading it correctly. JM performed their inspection on August 20th, 19, and has decreed they will not honor the warranty on the TPO, regardless of the fact that patches had been installed. Did I read that correctly?
Yes.
Did you ever do any investigation as to whether that had always been JM's position?
No, I did not.
Okay, so you weren't aware that prior to August 20th of 2019, they actually said they would warranty the roof with the patches. You weren't aware of that?
I was not aware of that.
Okay, thank you. And that, for some reason, they changed their mind at some point. You weren't aware of that?
Objection.
I was not.
Overruled.
Okay. Let's find the second page of this. If you go to the front of this exhibit, let's go to the second page. me see here, 318. Okay, there's a note dated 318 that I had a question of, I was curious about. Starts with, I have been informed. I have been informed recently by Brandon Paul with Commercial Roofing that he is no longer retaining Taylor Shaw to assist in this matter. Do you see that note?
Yes,
You had been dealing on and off with Taylor Shaw throughout this whole claim, isn't that right?
yes,
In fact, you called him a loss consultant at
Yes.
some point, and he worked for Brandon Paul and Commercial Roofing, right?
yes.
Do you know why Taylor Shaw was no longer retained to assist?
Well, Taylor and I had come to an impasse over how much the cost of the roof repairs should be. He was asking for way too much money to fix that roof, and I eventually spoke with Brandon and I said, look, we can't come to an agreement with Taylor, and that's when Brandon fired Taylor.
Okay. So Taylor, if I'm not mistaken, some documents I've seen, had put together some kind of estimate of like $2 million or something that he was attempting to get Travelers to pay on this, right?
Yes,
And you thought that was not reasonable,
that's true.
and you weren't able to work with him on that. Is that fair?
Yes,
And as a result of that, and a result of the behavior of Mr. Shaw, it's your understanding that Taylor Shaw was fired by Brandon Paul
that's true.
because of his behavior in this loss. Is that right?
Yes.
Okay, all right. Getting back to the other available insurance issue, I don't see anywhere in any of your claim notes where you contacted either American Fireworks Company or the city of Willoughby to determine whether there had been any documents indicating that you're insured, the Willoughby Eastlake School had ever been added as an additional insured to any other policy. I didn't see that you ever made that inquiry.
Added to an additional insured other than the builder's risk policy that I was working the claim for.
Yes.
If there are no notes in the file, I can't say that I actually did.
Okay. That was a mistake not to have done that, isn't it?
Well, I talked to Steve Johnson about this, and based on what I had found, I had no reason to believe there was other insurance on this.
Okay. Did you look at did you contact the city of Willoughby that was the sponsor of the fireworks display?
No, I did not.
Wouldn't it be a reasonable inquiry on your part to see if there was any insurance available to the city of Willoughby that may or may not have added the school district as an additional insured?
Perhaps, but there's a tool that we can go to called ISO. It's called the Insurance Services Office, and they publish a list of all claims that are filed on all policies nationwide. If I had wanted to find out whether there was other insurance, that is the first source that I would have gone to, and I went to that, and I actually reported on that in one of my file notes that there is no other insurance.
Well, let's back up again.
Okay.
The claims made against other policies.
Yes.
Okay. First of all, where in your claims notes do you make reference to this ISO?
They're in the file.
I'm sorry?
They're in the file.
In these claim notes?
I don't know whether you have that particular claim note, but there is a reference that I made early on in the claim when I did my large loss report that there was no other insurance.
Well, are you saying there was no other claims made against any other insurance policy, or there's no other insurance?
That's really the only way that you can find out if there's other insurance. I mean, if the insured has another policy somewhere out there, it's really very difficult to find out if there's a policy unless there's a claim made on that policy.
Well, like I said before, or you could do some research into the circumstances surrounding the event that gave rise to the property damage, in this case a fireworks display sponsored by the city of Willoughby, and you could ask somebody whether the city of Willoughby had insurance on the policy or on that performance, and whether your insured was added as an additional insured. That could be done too, right?
Are we talking about a separate first-party policy or a
Yes.
third-party policy?
No, adding a
Well, true.
policy of insurance that specifically adds your insured as an additional insured for the events that gave rise on July 4th, 2019. You could have asked the city if there was such a document.
Well, this was a builder's risk policy. Now, with builder's risks, The policy, the property is still in the hands of the contractor. All right, so all of those materials that were damaged were theoretically really not owned yet by the city of Willoughby, Eastlake. Okay, they were the property of the builder. But a builder's risk policy insures that type of property. And that was the intent of the builder's risk policy.
I guess I should just ask the question. You never asked, right? You never inquired, you never had anybody, you never asked your insured to check with the city of Willoughby to see if the East Lakes Willoughby Schools was added as an additional insured to anybody's policy. You never asked.
I never asked.
Thank you.
Are you done?
Oh, yes, I'm sorry.
Okay.
Did I not say that?
No. Redirect?
Thank you.
I'll be very brief, Your Honor. Thank you.
There was a question about the repair and replace question, and that arose early on, very early on in the claim. There's been testimony here about the insulation underlying the membrane. There's been testimony about the overlay of the membrane on the prior membrane and cutting, disabling the prior membrane underneath. And the $2 million, estimate that you were asked about, is that the distinction that's being drawn here between total tear down, which would have been the $2 million estimate, versus what actually happened that Mr. Runyon recommended, the overlay?
Yes, essentially. I mean, we did not agree with the scope of repairs that Taylor Shaw was asking for, which was far more extensive than needed to be done.
All right, and then with regard to, you were asked about Mr. Runyon's report and what that did or did not say. Mr. Runyon has been here and testified to his report, and what it does say, you would defer to whatever he testifies here on his own report?
Yes.
You wouldn't second guess you wouldn't read his report and try to counter or cross anything that he said about it?
No.
Okay. And then did you happen to know whether or not Taylor Shaw, who Brandon Paul decided to take off of this matter, was an employee of CCRS or a consultant?
He presented himself to me as an independent consultant, so I would assume he's self-employed.
All right, so you said fired. He more or less, he would have canceled whatever contractual agreement they had between.
Well, I don't know. I never saw the contract between Taylor and Brandon Paul. He was just verbally presented to me as Brandon's consultant.
In any event, he took him off the job. Is that right?
That's true.
All right. He just wasn't agreeable.
He was digging in on a lot of issues that we just did not agree with. As you know, as was mentioned earlier, he wanted a complete ISO board takedown. He wanted duplicate layers of overhead and profit on the work that was being done. My preference was just to deal strictly with the subcontractor, which was Brandon Paul.
All right. And how did you deal with him? How was he to deal with for you?
Excellent. Very agreeable.
Okay. And then on the, you testified about ISO search. Maybe that was interesting. I'm not sure I knew that before, but so is that a search? There were questions about additional insured. To your knowledge, is that a third-party liability matter or a first-party, and does that impact what you would do in terms of pursuing any coverage of that nature?
Now, do you mean doing an ISO search? Typically ISO only deals with first-party claims. Now, you can find some third-party things on there, but I was only interested in finding out if there was duplicate insurance from another carrier who had been notified that, we want to claim the damage at this building. That would have raised a red flag. And I would have said, okay, wait a minute, now we've got two policies here. How we would have handled that is the policies would have prorated the damages. In other words, if you have two policies with the same limits, we would have paid half the damages and the other insurer would have paid the other half.
All right, so that took care of first-party coverage. Would you investigate it into third-party coverage?
No,
Why not?
because that really doesn't fall under my purview. I mean, I'm interested in finding out if there's other duplicate insurance on the property that we're insuring. And yeah, there could be some liability policies that might cover it, but I'm a first-party property adjuster. We have a subrogation department that deals with third-party claims, and I let them do their job.
All right, so whose purview is that under then?
That would have been Bill Payne.
Thank you, no further questions.
No questions, Your Honor.
All right, you may step down, thank you. All right, next witness.
Steve Johnson, Your Honor.
You raise your right hand, please. You swear the testimony about gives the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat.
Will you state your full name for the record, please?
My name is Stephen Michael Johnson,
Can you tell the ladies and gentlemen of the jury what your occupation is?
Director of Operations and Security for the Willoughby East Lake City Schools.
How long have you been in that position, Mr. Johnson?
8 years.
And tell the jury what your responsibilities are in that position.
Pretty much operations from roofs, boilers, parking lots. If it's anything to do with the buildings, I'm in charge of. Security ends also on the hardware end of security. So all of our cameras, anything to do with walkie-talkies, vape detection, window film, that all falls under me. Students falls under another department.
Could we just say buildings then?
Pretty much, yeah.
Okay. And I would think probably parking lots as well.
Parking lot, yeah. You name it, it's pretty much covered. It comes through my department.
All right. Would you tell the jury, and you've been here through the whole trial.
Yes.
Thank you. Would you tell the jury what about the project that we've been hearing about here throughout the trial, the YMCA Senior Center and addition to the high school, and how that came to fruition and what your involvement with that was?
It started back in, I think, 2018. We received a bond to build 3 new buildings. At that time, I was brought on to assist in going to meetings at 4 locations on job progress. And we just went to the meetings every once a week into the trailer, discussed issues of what's concerning with, could be steel, could be concrete, could be whatever. And at that time, we'd go over different items, mainly to the build of the building. And then I would, when I left there, I'd go back and do my other role of operations of the other 13 buildings that we were occupied.
Okay, and I'm going to back up here just a step, if you don't mind. Could you tell the ladies and gentlemen of the jury, just sketch your education that has led you to the position that you're in today?
Yes, I formerly was working for electrical contractor, a local 38 wireman, worked my way up in the office of the contractor of Skyline Electric, which is based in Mentor, Ohio, and overseeing projects for him and their employers on jobs to make sure their performance on the jobs they were on was getting done on task. Then from there, I went to work for the Willoughby East Lake Schools as an electrician, knowing that I wanted to be in operations, knowing that the gentleman in operations, I knew him quite well, was going to retire. I then worked my way working side by side with him, so when he retired, I would take over his position.
And so you have quite a bit of responsibility. How many buildings are there under your purview?
13 buildings total.
What about that, is the campus where the fireworks display was held, is that the largest complex under your jurisdiction?
Yes, it is, yes.
Where are the other buildings located around?
Well, we have North High School, which is on the north side of town. We have Willoughby Middle, which is connected to South High School. We also have 3 elementaries, Edison, Jefferson, Grant. I have 3 middle schools. We have Eastlake Middle, Willoughby Middle, and Willowick. I think I got them all. And then in charge of the board office and transportation.
That's a lot of roofs, right?
Yeah, I think I got them all.
Are within those buildings, and we've noticed in this, in the complex that we are here in now, there's 2 different types of roofs, on at least 2 different types of roofs on that building, a metal and TPO. Are there other kinds of roofs around?
We have a hot tar roof on the Willoughby Middle School roof. And then we also have a TPO, similar TPO roof on that too. There's parts of it, there's sections of it.
Okay, so you know something about the different kinds of roofs that are marketed?
Yes,
That's
you
fair
learn
to
over
say.
time because we have went out for bid for projects besides the one that we're in dispute now with, to get pricing on different types of roof, membrane and stuff like that. Yes, I've been involved with other roofing companies for pricing.
And what's your understanding of the TPO product in general?
In general, it's a great product. It's been more cost effective to go with that than other means. So we've been going towards TPO through the other roofing companies that I've dealt with. It does have some factors. When you do go up on a roof, you have to make sure that you be careful what you're doing up there, because it is very vulnerable to punctures and stuff like that.
And essentially, why is it, from your observation and experience, why is it vulnerable to punctures?
I've seen, there is times when people go up on the roofs and they're bringing their tools up there, and you just got to make sure you watch, and our plant supervisors make sure that, hey, you be careful of your tools when you're up on the roof because of possible punctures.
Okay. And are you familiar with the warranties that typically would be associated with TPO roofs?
Yes.
Tell the jury about those.
Well, the warranty in regards to this one was the 25-year, which was concerning to us because we, as a district, I hold it really responsible to the community that we get the full warranty of our roofs, because of any kind of other than the 25 or 30-year warranty wouldn't work for us. It would be going back after the taxpayers for another bond issue to replace our roof sooner than what we should.
Okay. And this TPO material, have you walked on it yourself a fair amount?
Many times, yes.
Okay. And so in light of the material and your experience with it, are those warranties of particular concern on a TPO roof?
For sure, yes, I would say yes.
And then you were discussing, I believe that you were referencing meetings that you go to, you went to throughout the construction process of the new complex.
Correct. We're to respond to 2 meetings. One at the architect's firm every Monday. That would be to go over just general, it could be furniture, it could be tile color, it could be all sorts of crazy things when it comes to architects. And then I would have to go to the construction meetings, which was actually the trailers. And that would be day-to-day, what was going on the week prior, what do we need to look forward in the future of, what concerns we have. If we're going to get the material on block there on time, or we're going to get the cement on time. We were under a very tight deadline because school is going to be opening the following year.
So at the time, in the run-up to the July 4th, 2019 display, what was the stage of construction?
It was, that day I would say we were probably Well, we had to be pretty close at that time because we had to be about 98%. I mean, we had to be pretty close because school started in August.
All right, and what was the state of the roof at that time, to your knowledge, on the new construction?
I was told in the production meeting that it was pretty much 99% done. They were going to get their final.
And you heard the testimony of Mr. Runyon here
Mhm.
that he had been out there a few days before,
Correct.
and was that consistent with your recollection?
Yes.
And so when you go to the construction meetings, what topics are discussed?
Well, mostly the topics start with the South High School being the biggest part of the whole project. So I would go first, and we would talk about individual problems with South High School. It could be the pool area, it could be the gymnasium, it could be anything. So John Lacina would ask questions to me of change orders, is there overtime approved, and stuff like that would all go through me. And then we just basically update it from him as the progress. And then there would be a progress book that we'd get that at that time to go and say what progress line item we're down to, what date we're going to make, or we're going to make these deadlines. And then we'd go to the next group of people, which would be either the senior center or the Y, and then they would speak on their behalf of what their issues were in their buildings and what they had going on.
Is fireworks typically a paramount concern when you go to these meetings?
No.
Do you ever remember fireworks being discussed at any of those meetings?
I think Judine did bring up fireworks on when it came to her discussion about her building, that came up about fireworks, yes.
You say her building, which,
Would be the senior center, I'm sorry.
all right. And was that something that involved you when Judine was discussing that?
No, it wouldn't have impacted me.
And why is that?
Because here again, the fireworks was always done by the city of Willoughby and American Fireworks. I've never dealt with either of those two parties when it came to fireworks. It would just be brought up that we're going to do the fireworks display on this day. We need to fence off the parking lot, and that would be that's all I would get. And sometimes they would just show up and fence it off. We know the fireworks are coming. So the city would show up, start fencing off the parking lots and stuff like that.
Okay, and these fireworks displays, had they been done, to your knowledge, in prior years on the school grounds?
Oh, yeah.
And in prior years, do you know whether the new construction was under a TPO membrane?
No, it was not at that time.
Do you know, and you, again, heard all the testimony throughout the trial, and you saw the diagrams with the red boxes and testimony about where the fireworks were launched from. Do you know whether they had ever been launched from that location prior to?
No, I was actually surprised when I saw where they were launched from.
Okay. Did you see, were you there during the launch?
No, I was not.
Okay. When did you find out that they had launched from that roadway close to the school?
I received a call. We had a production meeting down at TDA that day, the following Monday. So we were down there. I received a text message to call 911. So I was like, oh, great. So I'm like, okay. So when I got the call, I got out of the meeting, I called. They said, you need to get back to the job site. When I went to the job site, they said, you need to go up on the roof. And then at that time, I was meeting with John Lacina, and I was meeting with Brandon, Paul, to go over what happened.
How did you feel at that moment when you went up on the roof?
Sick to my stomach. It was bad.
Okay. So then go on and tell me about that time that you spent up on the roof.
Well, seeing that we were crunched down to opening school, I have a roof now that has been damaged. So we go into getting back to the treasurer, finding out what policy we're going to turn it to, go to. And he said at this time we're going to have to go to call Travelers and have them come out and take a look at the road. So at that time, that's when I started calling people right away because of obviously, if there is going to be a storm or rain coming, we want to make sure we seal the building up to save it whatever we can in damages. And at that time, we called in, and the first adjuster came out, which I don't really remember him coming out, but he spoke, they looked at it, and then the process started.
Okay, tell the jury what you observed across the field membrane. We've seen pictures here, but we haven't heard too much narrative about just what you saw up there. When you were called up there, 911.
When I got up on the roof, I had seen nothing but, there must have been 15 people from the city of Willoughby up there, which is not uncommon for them to come back the next day and clean up firework debris on the parking lots and sidewalks. They've done it for years. But they were up on the roof, sweeping the roofs and cleaning the debris off the roofs. And then I went to our roof, and I'm like, oh my God, it's all the way over here. And then I just started walking the entire roof, and the debris was everywhere. And I'm just like, now I went over to Willoughby Middle, which Willoughby Middle, being the hot tarred roof, didn't get impacted. It actually, there was debris on it, but it was fine. It was minimal debris. It was fine. And that was what I saw. I mean, metal roof, which is over the field house, had debris also on it, which we saw photos of.
So was there any roof system on that building that wasn't impacted by this?
No, everything was impacted. I was surprised how far it went.
Were there other building systems impacted, such as gutters or?
Yeah, the metal roof had so much debris on it, they tried to sweep it down, clean it up the best they can, but it went down into the gutter system, because we did have a storm. I think rain came in later that week or whatever.
And you mentioned, I think you said part of the roof was rubber as well?
Over at the Willoughby Middle, but that's far off to the other side of the property.
So did you notice whether there was damage to the membrane?
I'm sorry?
Did you notice whether there was damage to the membrane?
Of the TPO south roof or Willoughby Middle?
The south roof.
Yeah, there was damage to the roof.
Okay. What did you see?
We saw burnt marks, pop marks all over the place. And here again, I'm looking to the roofing experts to tell me about this damage to this roof. What is the status? What am I looking at here? I mean, I see burn marks all over the place. What does this mean to me? Are we replacing a roof? What is the extent of damage here? That's what I need to know to report to the superintendent and to the treasurer.
So you're not a roofing expert?
No.
Okay. What did you do when you heard from the roofing experts, their points of view about it?
My biggest concern was how fast we can get it fixed, because I have opening of a school, grand opening of a brand new school right around the corner. I have to also look at the fact that what is this going to take to finish? What is this going to do for us? This impact also needs to be reported to the board, our board, as to what happened, and to the public, because they're seeing things going on that they thought were done.
To your knowledge, did American Fireworks ever come to you to ask to look at the membrane and see what damage there was?
No.
Were you ever contacted by American Fireworks about this at all?
No. I've never met the gentleman till the first day he was up on the roof.
Eventually, to your knowledge, did American Fireworks, or was American Fireworks called to come out there eventually?
Yes.
Do you know who called American Fireworks to get them out there so they could look at it?
I'm not sure if it was the city, because here again, it was a city event that they put on, that they actually managed, they paid for. I really would have no impression or nothing to do with that. So I would assume that would have been Judine.
Yeah. Well, you didn't sign any contract with American Fireworks, correct?
No, I did not.
Okay. American Fireworks never contacted you to explain to you what they were going to do and how they were going to do it on the grounds?
No.
And you are director of all the buildings around the Willoughby East Lake City School System. Did anyone within the organization tell you at any time that American Fireworks had contacted them in order to discuss where fireworks are going to be launched and what they plan to do?
No, like I said, this was always handled by the city, Judine, and the fire department. I was never involved in any of these discussions.
And again, you've been here the whole trial and you've heard testimony about a contract that was drawn between American Fireworks and the city of Willoughby. Do you recall some of that testimony?
Yes.
Okay. And do you recall when it was testified that in the contract, it says that
Objection.
Overruled.
it says that the display company will provide to the client, in this case City of Willoughby, public liability and property damage insurance, and will add the sponsor of the project and the property owner of the location as an additional insured. Do you remember that testimony about that clause?
Yes.
Okay, did you know as the owner of the property that there was a promise that applied to Willoughby East Lake City Schools?
No.
It also goes on, and you would, do you recall hearing the testimony as this clause goes on, and it says, in addition, any property owner in the fallout zone and any municipality where the show is being performed, if applicable, that requests to be named as an additional insured and is approved by the client that is providing a fireworks display should be added as an additional insured for the fireworks display at display site 36901 Ridge Road, Willoughby, Ohio. Is that the complex that we're discussing, that address?
Well, the address is 5000 Shanklin, but they were probably talking the one up on Route 84, which is Ridge Road address, possibly.
All right, well, as a building owner in the fallout zone, were you ever made aware that you would be able to request to be added as an additional insured?
No, I was not.
And in hearing the testimony of the contract, in which it indicates that the display company shall be responsible for an inspection of the display area and fallout zone for debris and other items related to the fireworks display. Would you, do you understand that clause?
No, I don't.
Okay. Do you know whether that clause was in there to benefit you?
No, I did not.
If American Fireworks had done an inspection, do you think that would have been a benefit to you if they had inspected the property after this display?
Sustained.
Do you recall testimony regarding the contract and the clause indicating the display company shall prepare and secure all permits associated with the fireworks display? Do you recall that?
No, I don't.
Do you know whether if American Fireworks had secured the permits and according to city ordinance, whether that would have benefited you in the school system?
Objection.
Sustained.
Would you have, is there a reason that you would accept an unwarranted TPO, $1 million TPO membrane over a brand new senior center, YMCA, and school addition?
Objection.
In his capacity as a director of operations, you're speaking?
Yes.
Okay, overruled.
Could you state that question again, please?
Yeah, as the director of operations, would it be acceptable to you to have the membrane over the school addition, YMCA, and senior center unwarranted, unwarrantable?
No, I owe it to the community to make sure I got a warranty on that roof.
So you indicated you then, you went to Travelers for
Correct.
refuge. And what happened then?
After that, I pretty much, Travelers got involved, and I was just in the, kind of the back seat because they were dealing with Brandon Paul and John Lachina at the time. John Lachina was just helping out with the process a little bit because of, it's still his project, he was running the project, but technically, when the roof was damaged, he was now out of the equation of the roof part of it now. Now it would turn into an insurance claim. An insurance claim was dealing with the roofing company.
And you heard the testimony of Mr. Ellis here, correct?
Yes.
From his side on the claims process. From your side on that process, how did that go?
It went extremely well. I dealt with Jim quite a bit. He was questioning a lot of the pricing, and here again, that is not in my wheelhouse to know what pricing per square foot. You, as an insurance company, would know that better than I would, and along with the roofing company. So as he would come to me and say, these prices are a little out of line, we need to talk to Brandon Paul, Commercial Roofing, and see if we can get this dialed back in. And that's all, pretty much we went back and forth on that. And he would then tell me, Brandon would tell me if I needed to contact Jim Ellis, if there was any additional things that need to be done, like the gutters and some other additional things that had to be done. I just reached out to Jim and say, hey, Commercial needs to get this, wants to get this done. And at that time, he'd push that through if he had to.
With Travelers involved, did that project get finished?
Yes.
And how did that affect your schedule?
We were still doing roofing all the way up into colder temperatures. So we were probably still going into, I think, November, trying to do off hours, weekends, whenever we could to try to eliminate as much noise to the building, because we were now open. This district was open, the building was open.
So kids were able to go back to school because you got a roof on.
We got a roof on and we got an occupancy permit.
What if you were still waiting for American Fireworks to take care of it?
I'm not sure what we'd do at that time. We'd probably have to find another facility.
Is that project completed now?
Yes, it is.
Do you know the appraised value of the completed project?
The whole project, we have it appraised for $50 million.
You have it, is it insured now?
Yes, it's insured.
Thank you. That's all the questions I have.
Cross-examination.
Thank you, Your Honor.
Mr. Johnson, I want to make clear certain things that you just testified to. First of all, there was no delay for complication in the school opening that school year as a result of anything that occurred on July 4th of 2019.
I never said there was.
Well, I just got the impression that you thought there was danger of the school not being open by time.
We didn't know how long it was going to take to replace the roof, but there was no delay in schedule, but we were replacing the roof when school was in session.
Okay, so you're not leading this jury to believe that you weren't able to start school on time regardless of July 4th?
I never said that.
And in fact, the roofing replacement project wasn't completed until April of the next year, right?
I'm not sure, is that, I'd have to look at the records, I
Well,
don't.
you heard testimony yesterday that the warranty was issued on the completion of the project, which was on April 8th of 2020. You heard that testimony?
Yes.
yesterday? Okay, so that's when the project was completed, right?
Yes.
The school district itself has its own contract with American Fireworks Company, doesn't it?
I'm not sure about that.
You don't, you're not aware that your rec director, Tom McKinnon, you know who Tom McKinnon is?
Oh, then that's the cannon that they shoot off.
Yeah, at the football field.
Correct, yes.
And the football field, is that within your jurisdiction of buildings you can?
That comes out of Tom McKinnon's budget for fireworks, so I would not know that American Fireworks was involved in that. That doesn't come out of my budget.
You don't talk to him about that?
No, no, that would not be in my wheelhouse, the cannon.
So if I tell you that as of even today, the Willoughby Eastlake School District has a contract with American Fireworks Company, you're hearing that for the first time?
I am hearing it for the first time.
You never asked around to anybody?
No,
Let me finish my question.
I'm sorry.
When you were investigating this issue as to what, you know, what happened at the fireworks on July 4th, you never asked whether the city of whether Eastlake Willoughby School District had contracts with American Fireworks separately?
No,
And were you aware, as you sit here today, that they still have a contract with the school district, even after all this?
I wouldn't, yeah, okay.
You're hearing that for the first time?
I am hearing it for the first time.
And you're the director of operations for the Willoughby Eastlake School District?
Yes, but I am not the athletic director for South High School that is in charge of the cannon.
And you're aware, or are you aware, that American Fireworks Company, to this day, still performs the Fourth of July fireworks for the city of Willoughby? Were you aware of that?
Yes, I am, yeah.
And were you also aware, being the director of facilities operations, that the American Fireworks Company did the fireworks display at that location, 5,000 Shanklin, for about 20 years prior to, about 20 years prior to the July 4th, 2019 display?
I believe you're correct. I don't know exactly how long, but I know they've done it for a long time.
Without any problems, as far as you know, right?
Correct.
And they shot the fireworks off at a different location prior to the construction, location on the property though. Were you aware of that?
Yes.
Okay, can I have, I know I didn't tell you this, Steve, but can I have AA, please? Mr. Johnson, this is, there's been testimony regarding this document, and that this is a photograph of the site of the school prior to the construction of the new addition in the YMCA building. Do you recognize that?
Yes.
And were you aware of where the fireworks display was located
Yeah.
prior to the construction?
Yes.
Where was it located?
Generally, where the softball fields are, where the big grassy areas.
Is that where that 600 number is?
No, it'd be more towards the center of that.
Okay. Was there anybody ever checked the roof of the unoccupied building after any of those fireworks displays to see if there was any debris from the fireworks?
Not that I recall.
Nobody ever checked?
No.
Any damage ever done to that roof?
That roof was
From fireworks? From fireworks?
not that I know of, no.
Now, you testified at the beginning of your testimony that you have a certain degree of knowledge and experience about this particular roof TPO system, and that you described it as a great product. It's cost effective. Does that mean it's cheaper than other roof systems?
I think overall, yes. I mean, when you put the labor to it, yeah.
But you gotta be careful with it, I think you said.
And I'll say it again, yes.
Okay. Now, you described to the jury your involvement in the construction activity, in the construction process, by attending regular meetings.
Correct, weekly.
You would attend regular meetings of the construction, can I say team, at the architect's office?
Yeah, we all reported there at the same time, a team.
And who would be there? Representatives of the architect would be there?
Yes,
Representatives of the general contractor would be there?
yes,
Representatives of the construction manager would be there?
correct,
Representatives of the city of Willoughby would be there?
yes,
And representatives of the Willoughby Eastlake City Schools would be there, right?
correct,
Yourself
correct,
and others,
correct,
a number of other people.
correct.
Right?
Yes, could be like four of us or five of us there.
Robin Hopkins,
That was the principal,
Patrick McKinney,
computer services.
Jim Marmimo,
AD at the time for South High School,
Steve Thompson.
superintendent.
Now, at some of these construction meetings, would there be discussions among the construction team about how great the TPO product was, how cost-effective it was, but how careful you needed to be about it?
No.
You weren't present when there was any discussions whatsoever with the construction people about the TPO product itself?
Our meeting consists of the owners. It didn't consist of any of the contractors. They would have a separate meeting.
Well, you just said that the general contractor.
Well, the general contractor would be there, but the subcontractors would not be at that meeting.
Well, the general contractor doesn't know what kind of products the subcontractor.
He should,
Overruled.
Wouldn't the general contractor generally be aware of what the roofing subcontractors are using in terms of product?
yes,
And wouldn't in fact the architects be the ones that are specifying the product?
yes.
Okay. So in May and June of 2019, when Judine Banker, and you heard her testify,
Mm-hmm.
said that on two separate occasions, on May 29th and June 12th of 2019, she advised the whole team, including you,
Yes, I was at the meeting.
that the fireworks display would be set up in the parking lot of the future senior center. You were there.
Mm-hmm.
Okay. So there was no surprise that this was happening, right?
No, there was no surprise that the fireworks were going to be blown off.
And you heard Captain Kokap testify that about 4 or 5 days prior to the event, the city went out and set up some snow fencing on the school area to separate the crowd from where the display would be and to, because there's still a construction site, to protect those areas as well. Right?
Yes, yes,
So you were aware this was happening and this was coming? Is that
correct.
right?
Every 4th of July.
Okay. And were you there that night, by the way?
No, I was not.
You're the director of operations for the school district, and you didn't attend the fireworks display that was happening in your school district?
No, I do have a personal life also.
Have you ever gone to the fireworks at that location?
Yes, I have.
On the 4th of July?
Yeah.
You just weren't there that night?
No.
is what you're saying? Okay. Now, did you ever do any investigation with anyone from the city of Willoughby as to the terms of the contract between the city of Willoughby and American Fireworks Company after the fireworks display? Did you ask them, what does that contract say?
No,
You never asked.
no.
You contacted the school district's own insurance company and it reported the claim.
Our building risk, correct.
Okay. And you never looked into whether or not the school district was ever added as an additional insured to any policies of insurance from the city of Willoughby or American Fireworks Company? You never looked into that?
No, I did not.
Now, you did attend, I heard you describe, you attended a meeting on August 20th. Can I have Jay, please? Next page. August 20th of 2019, which was about 6 weeks after the fireworks event. And you were there with, among other people, you were there representing the school district, is that right?
Correct,
This is Roberto Sorgai of American Fireworks was there, right?
correct.
Okay. Bill Runyon, the Johns Manville representative, was there, right?
Yes,
Fred Day was there,
yes,
and Jason Carper of Travelers Insurance, you see that?
yes,
The mayor was there as well, is that right?
correct.
Do you know Mayor Fiala?
Yes, I do.
Did you talk to Mayor Fiala
We-
that day?
We spoke just hi, how things are going. We pretty much I sat back, I think as long as, I can't speak for himself, but I was letting the professionals do their thing, walk the roof, look the roof over. That's not my forte. So I was there representing the Willoughby Six Schools, but that was all.
Do you know about Mayor Fiala's background?
Yes, he's an architect. He owns Then Design in downtown Willoughby, yes.
Which was the design firm that was actually engaged in the addition, is that right?
Correct,
Representatives of Venn Design would be at these weekly meetings
Correct.
Okay. So the mayor was associated with the architectural firm that was actually doing the project, is that right?
That did the build, yes, did the design.
Did you speak to the mayor
Just
that day?
small talk, hi, how you doing, how's things going, nothing about the actual incident, no.
Did the mayor show you anything about the condition of the roof as installed that day?
Not that I recall.
Was he taking any pictures?
I don't recall that.
Did you observe whether or not the mayor was involved in any of these conversations with the Johns Manville representatives or the insurance
I would
representatives?
not know that.
Okay. You heard Mr. Ellis testify that the insurance notes indicate there was an argument that took place that day between the owners and the contractors about whether or not the roof could be replaced or repaired. You remember that?
No, I do not.
You don't remember that testimony is what I'm saying?
Oh, I remember the testimony, yes, yeah, I'm sorry.
Okay, all right. And there was a note from this Jason Carper added into the notes summarizing that, is that right?
Yeah, that's,
Do you recall an argument between the parties as to whether the roof could be repaired or replaced?
I don't recall an argument.
Okay. So you didn't participate in any such argument?
No,
Is it fair to say that your position from the start of this whole process was that you wanted a new roof, right?
I wanted what was deserved to the community as a 25-year warranty.
Okay.
And to get that, it came out to be a new roof.
Okay, can you back that up? Let's look at the warranty sentence. You see the sentence on this report saying, I'm sorry, have you ever seen this report prior to this trial?
No,
Okay, all right. So that sentence, due to the third-party damage, you see that? This is a statement made, and you heard the testimony of Phil Runyon. Due to the third-party damage to the waterproofing membranes of the new system, Johns Manville cannot issue a guarantee on this roof system. Did you see that?
yes.
Do you know whether or not that was always John Manville's position?
When he was out on site, he did say that there would not be a warranty on this roof.
But you heard him testify here in trial that on 2 occasions he indicated that if the repairs done that he recommended were done, he would have warranted the roof. You heard him testify.
That's what I heard here.
Okay. The school district paid a $5,000 deductible as a result of this claim, right?
Correct.
So that's all the money, dollars, that the school district is out as a result of this dispute?
And a lot of my time.
Okay. I asked you about money. Okay? That's what the school district paid, $5,000, right?
Correct.
Thank you.
Redirect? Yeah, thank you, Ron. Could we keep that up, please, rather than have, thank you. What? What is it? Oh, okay, so, just so we're clear here, there's been a lot of questioning and about the football field and what happens there with American fireworks. I think we just heard for the first time, that's not a firework display over there.
Correct. It's a cannon.
Okay, so they're allowed to shoot a cannon off on that campus, but since 2019, they haven't shot any fireworks off on that campus, have they?
No, they have not. They've
And-
moved the location.
Will they ever shoot fireworks off again from that camp, as long as you're in charge?
No, they will not.
And the Willoughby East Lake City Schools is out a $5,000 deductible on this, aren't they?
Correct.
And you were asked about the August 20th meeting that Mr. Fogarty brought up here with the participants and the attendees. Again, between July 4th, 2019 and this meeting where American Fireworks Company was asked to come out to the site, to your knowledge, they never went up on that roof in all that time period, more than a month?
Prior to that, no, that, of my knowledge, no.
And you did hear Mr. Runyon's testimony about what he recommended in July of 2019. Do you recall that he talked about the gridding of the roof and the disabling of it? Do you recall
Yes.
that part?
There was talk about how they would have to disable the roof.
All right. And that was in July of 2019?
Correct.
Thank you, nothing further.
Anything based on redirect?
Yes, Your Honor. Again, Mr. Johnson, I'm concerned that you might be giving this jury false impressions about certain issues.
Well, let's keep the commentary eliminated. The jury's instructed to disregard that. Ask a question.
You were asked by Mr. May about American Fireworks Companies, the timing of their inspection of the property. You were asked, had they, to your knowledge, have they been up there prior to August 20th of 2019? Are you aware of when American Fireworks was first made aware of the issue, period?
No, I was not.
Okay, so I'm going to show you Exhibit I here. Let's see the following, let's see the date of this. I'll represent to you, this is an email from Mike Lucas, the law director of the city of Willoughby, to Roberto Sorgai of August 14th of 2019. You see that?
Yes.
All right, let's go to the following item. Dear Mr. Sorgai, following up on our telephone conversation of this morning regarding the damage claims for the roof on multiple buildings. Let's go to the next paragraph. At the present time, a scheduled meeting has been set for Tuesday, August 20th, 2019, beginning at 10 a.m. You see that?
Correct, yes.
Now, if I indicate to you that's the first notice that American Fireworks got of some claim being made that their fireworks caused damage to your roof, you have no way to disagree, or do you have any way to disagree with that?
No.
So you didn't mean to infer that they were dilatory or delayed their inspection when they were there on the 20th, right?
I did not have a contract with American Fireworks.
You need to answer that question, please.
I'm sorry?
You weren't attempting to infer that American Fireworks ignored or was dilatory in inspecting or coming to the school when asked about the claim for fireworks damage.
No.
Overruled.
That's all I got, thanks.
All right, you may step down. Thank you. Let's see, plaintiff have another witness?
The plaintiff, no, Your Honor, plaintiff rests with admission of its exhibits,
All right.
subject to the court's orders.
All right, ladies and gentlemen, the plaintiff is rested in this matter. That means they have presented all the evidence they intend to present. We have some work to do outside of your presence, so I'm going to give you a break. It's probably going to be at least 15 minutes, maybe a little bit more. Remember not to discuss the case. Don't try to look for any other information outside of what you hear in this courtroom, and don't come to any conclusions. We'll see you in a little bit. Have a seat. Okay, as to the exhibits,
Yeah, we move for admission to our exhibit list, subject to redactions of, as the court's instructed, which are exhibits. We have exhibits 1 through 51, Your Honor. Move for admission.
Well, Your Honor, I would just, assuming the redactions are what they claim they are, I don't know, how do I ensure that? Should we do that
well,
offline?
you guys are going to get together. I mean,
Okay,
as I recall, there were 5 and 6. same contract, but I think 6 was unsigned. I thought there was one other one also that included that contract, but I'm not sure.
I'm just suggesting we do that at another time.
Right, you're not gonna do it now, right.
Okay.
So 1 through 51 admitted without objection, subject to the proper redactions, correct?
Yes, Your Honor.
Thank you, Your Honor.
All right. Mr. Fogarty?
Yes, Your Honor. At this time, I am going to be moving for directed verdict on plaintiff's claim for, plaintiff's claims for damages due to the alleged failure of American Fireworks Company to add the school district as an additional insured to the policy, as there was no testimony that they failed to do that. There was no testimony one way or the other. They simply inferred that maybe that happened, but no one testified under oath that American Fireworks Company did not add the school district as an additional insured. And I see that your office, Your Honor, has included a jury instruction to that effect.
Well, I sent you guys a draft of the instructions based on what we've heard so far, so.
Right, so that count of the complaint I'm moving for a directed verdict on, since there is no evidence that that did not happen.
All right, Mr. May?
Your Honor, thank you, Your Honor, we did submit the COI. That does list, but based on Mr. Johnson's testimony, there was no other coverage. They went to Travelers, and Travelers did a search and found no coverage. That was Mr. Ellis's testimony.
What was what exhibit was the COI?
The one that was, yeah.
Which number was it?
Yeah, that was,
It was early on, wasn't it?
Yeah.
yeah. It was, I think it was 6. if I recall.
By the way, the other
It was in
redact.
6, yeah,
hold
it's
on,
in 6, Your
Before
Honor.
I forget this, the other redaction is in Exhibit 1,
The permit,
in the contract where it says, in the amount of $10 million.
Yeah.
Combined single limit, that gets, okay. So,
yes, and then it was Exhibit 6 has this certificate of insurance in it.
Which is what would require the additional.
Down at the bottom, Your Honor, they are listed as an additional insured.
And frankly, Judge, I don't think Dennis and I ever saw that before.
What?
Just before trial.
Well, that's
What's
not-
that?
I didn't,
Wait, I didn't hear what he said. Doug said.
I just said that the way that it's listed here in very fine print at the bottom, I've never seen one like that. I don't think Dennis and I ever saw that before. But for 2.5 years, we sent a letter to this company claiming the right as an additional insured, but I have not heard from them to this day.
if I can respond, Your Honor, it was not part of the original complaint. As you may recall, Your Honor, this complaint was filed and then dismissed and then refiled, and it only became a part of the case upon the refile. And they have been in possession of the certificate of insurance that shows the school district as an additional insured from the beginning of this case.
Where are you on that?
Yep.
What exhibit are you looking at?
Exhibit 6, and it'll
6.
be at page
Page 2. 6, page 2.
It's way down here in the fine print.
If I can approach, Your Honor, I'll show it to you.
This is their exhibit.
Relax, huh? You can take it easy.
fine print and small.
It's like, it's not small, it's tiny.
They're not responding.
They're not a party to this
Again
case.
before trial.
They're not a party to this case. I don't represent them. I'm not responsible for what the insurance company does and does not do.
So they did add as an additional insured.
That's from an agent, that's what I told Dennis this morning, that's what the certificate, the agent said, but the company we have not verified. The agent produces the certificates of insurance.
What company?
THE Insurance.
Okay, okay. And this is 6, the second page is 6, right?
Yes.
Okay. All right, let me check something and I'll get back to you on that. Anything else before that?
No.
Okay,
Nothing from Quinn, thank
and then you've got,
Oh, I'm sorry. We had stipulated that there's gonna be a stipulation that results in the dismissal of Eric Johansson as a separate defendant.
Okay.
Do we do that now?
I'm fine to do that now, yeah. Judge, I put it in your jury instructions, we would take out the respondent is superior instruction. We wouldn't need that, we would ask for, and we agreed to, if the court reads a stipulation that he, at all times, is in the course and scope of his employment in American Fireworks is responsible.
why don't you guys, while I'm in the back, write up exactly what you want me to tell the jury with
And then
regard to
you'll
that
be dismissed.
stipulation?
I think he's already done that. Have you already done
Yeah,
that?
I've got it.
Okay, all right. All right, anything else?
No, only that we would have him dismissed before I begin my case in chief.
Right.
Okay, nothing else.
Dr. Steinberg, I presume?
Yes,
Okay.
Should we agree on the language on the record then?
if you want to. I don't know if we need the judge in here to do that if you.
Okay, thanks.
All right, and then just give me something to read when I come back in and tell me.
Okay.
Okay?
All right.
Fireworks company is liable for any acts or omissions of Eric Johansson occurring while engaged as the lead pyrotechnician on July 4, 2019, and therefore the parties have agreed to dismiss Eric Johansson from this case. Is the defense ready to proceed?
Yes, Your Honor.
Go ahead.
Your Honor, we call Dr. John Steinberg, please. Is he in? Your Honor, can I approach the witness stand? So
Yeah.
somebody find this?
Will you raise your right hand, please? You swear a testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat. And while you're speaking, please stay close to that microphone.
Good morning, Dr. Steinberg. Thank you for being here today. Can you state your full name for the record and for the jury, please?
Sure. John Richard Steinberg,
And Dr. Steinberg, what is your business and professional address?
3944 Carthage, Carthage Road, Randallstown, Maryland, 21133, for my consulting work and for my patient care practice. If you want that address, it is the Bergand Group, 1300 York Road, Suite 100C, as in Charlie, Lutherville, Maryland, 21093.
Thank you for being here today. Can you describe for the jury what your present occupation is?
My present occupation is as a physician. I'm trained as an internist. We have a behavioral medicine practice. I have a board certification in addiction medicine, and I do patient care work. My other career for the past 30 years is as a pyrotechnician, an educator, a code writer, a display operator, and various aspects of forensic work, accident investigation, resolution of cases involving explosives and fireworks. And I've also been an instructor for a number of law enforcement agencies related to explosives and pyrotechnics.
Can you describe for the jury how you became involved in the pyrotechnics fireworks profession and industry?
Sure. Started off, I'm a kid, I like fireworks. And I always liked fireworks. And I like science. Obviously, I went to medical school. And I particularly like the science of fireworks. How do you make colors? How do you do this stuff? And as an adult, I was actually doing a medical lecture in South Carolina, and in the Airplane magazine, had an article on a guy that did fireworks displays. And I said, oh, this is cool. And then I get to where I'm going, and they had an interview in a local paper with a guy as far as I said, all right, I'm calling these companies. And in 1991, one of them said, come on up and we'll train you. And I started training, learned to manufacture, how to operate a display. After 3 years, they told me to go get a license in '94, and I started doing displays. State of Maryland, where I'm licensed. And then they told me I needed to join this organization, the Pyrotechnic Guild. So I joined, and they made me their lead instructor on training programs. I'm really not that good a pyrotechnician, but I do well teaching. And I realized they needed a program, so I wrote their textbook. It's been through 9 editions now. And then we have a seat on fire code committees, the National Fire Protection Association.
Can I ask you about that, Dr. Steinberg? We have your curriculum vitae up here on the screen. Can you describe for the jury the memberships in the professional organizations and review journals that you were involved in?
Sure. Let me wrap that last part up. So I got involved in code writing and everything else, and here I am today.
Okay.
All right. So the Pyrotechnic Guild International is an association of about 2,300 people. It's a 501c6 educational association for the promulgation of fireworks knowledge and information. The Michigan Pyrotechnic Arts Guild, the Western Pyro Association, the Florida Pyrotechnic Arts Guild are regional clubs, associations similar to the national one. The American Chemical Society, my undergraduate degree was in biochemistry. So if you have a chemistry degree, that's our professional organization. And they publish a journal once a week called Chemical and Engineering News. The International Association of Bomb Technicians and Investigators has two categories of membership: full membership for law enforcement and affiliate membership. And I maintain a full membership, which started when I worked as an ATF instructor, still a member. Our journal is called The Detonator, and it comes out 5 times a year and has information on explosives. American Fireworks News and American Fireworks Business are monthly newsletters. For general interest, the former; for the industry, the latter. The Journal of Pyrotechnics has ceased publication as of last year. Should take that out for next year. And Chemical and Engineering News is the ACS journal I just mentioned. That's a weekly journal.
Doctor, do you hold any state or federal licenses or certifications relating to pyrotechnics?
I do. I have a federal explosives license through the ATF for display fireworks and regulated explosives. What's called a responsible person. There's an RP, meaning you can use the license independently, and then there are employee possessors. I'm an RP, so I hold the license. It's through the PGI, but I'm on it. I also have a Maryland State Display Operator's license for both outdoor displays and for the proximate and theatrical pyrotechnic displays. And I used to hold licenses in South Carolina and Ohio, but no longer maintain them.
Are you involved in the training or licensure process for licensed operators in the state of Maryland?
I am. The state of Maryland organizationally for fireworks is the Maryland State Police. The fire marshals are in the state police. The deputy state fire marshal is our bomb squad commander, and he runs fireworks. He and I were just talking this morning. They have a council to advise them. It's called the Maryland Explosives Advisory Council. I am the chairman. One of my duties is I write the licensing examinations that are administered by this office.
Have you authored any textbooks, Dr. Steinberg?
I have. I'm the principal author with contributing authors of a display operator certification training manual, textbook of about 300 pages. I said, I think in 9 editions we've sold about 25,000 copies of that. But I gave the rights to the PGI, so I don't profit from that.
You're familiar with the National Fire Protection Agency, right, or Association, right?
National Fire Protection Association, correct.
And the NFP guidelines that govern fireworks activities throughout the nation, is that right?
Slightly, you misspoke. So it's NFPA guidelines, yeah, they're codes for how to do fireworks displays.
Those are industry standards,
Guidelines? Yeah, industry standard guideline. Some states adopt them, but even the ones that don't refer to them as an industry standard and a guideline.
Have you authored or assisted in authoring any state or national guidelines?
Yes.
Can you describe those?
I serve on 3 technical committees. NFPA has committees that write the codes. They're called technical committees, groups of experts. And I serve on 3 committees: hazardous waste disposal, proximate fireworks, and pyrotechnic outdoor display. And our document on the latter one is 1123. And since 1999, I have participated in writing 7 editions of that code, and just got a pin from NFPA for 25 years of volunteer service.
I should have asked you this at the beginning, but you're a licensed pyrotechnic displayer, correct?
Correct.
You actually shoot off fireworks.
I do.
How many shows have you shot off in your career, and how many do you do per year?
And as lead operator, I've done maybe 125 displays since obtaining my license in 1994. And now I pretty much just do 3 displays a year around July 4th, like 2, 3, 4, 3, 4, 5, depending on what day of the week the 4th of July is. But I do 3 communities fireworks displays pretty much.
Textbooks that you've written or NFPA guidelines or regulations you've been involved in drafting, are there any that have any relevance to the issues that are involved in this trial?
Well, yes.
Can you describe which ones?
Basically, the textbook is, I tell people, NFPA code is what you have to do. It's what the fire marshal enforces. And our textbook says this is how you do it. So one is the list of rules and conditions, and the other teaches you how to accomplish compliance with those goals. And obviously, they relate to the display of fireworks in an outdoor environment.
Have you previously been qualified as an expert and given testimony in fireworks-related litigation?
Yes, I have.
How many, approximately how many occasions has that occurred?
I sent my list of cases where I've testified at deposition or trial, and I think it's got to be close to 100.
Okay. When were you first asked or contacted to become a consultant in this case?
August 10th of 2023, Mr. Is it Sorgi or Sorgai?
Mr. Sorgai.
Sorgai called me and said, look, we've got a claim and I want you to work with, our company or,
Okay.
I said, sure.
What were you asked to evaluate with respect to your expertise in the pyrotechnic industry?
Basically two things. Number one, was this display conducted according to code? Were there any breaches of standard? Number two, was there any damage from this display to the roof that's been discussed at length?
Okay. What documents were you provided to assist you in this evaluation?
It's in the billing records I submitted, but essentially I received interview statements, filings, deposition transcripts, the edition of Code 1123-2014 that was applying here, copies of emails, photographs, et cetera.
Let me ask you about specific depositions you might have reviewed. Were you provided a copy of the deposition of Captain Michael Kokab?
Yes, I was.
And do you know who Captain Kokab is in relation to the dispute that's going on in this case?
Yes, I do.
Who was he?
Captain Kokab was involved in permitting and inspection, and during the display, he served as a spotter, observing the display in close proximity to Eric Johansson, the lead operator.
Okay. Are you familiar with the term of authority having jurisdiction?
Yes.
Can you define that term for the jury?
Okay. AHJ, as it's referred to in our trade. Every trade has lingo. Authority, this is the person who has ultimate ability to say yay or nay. It takes 3 people to make a fireworks show go on: the sponsor or host, the lead operator, and the AHJ. Now, any one of them can stop it, but the AHJ is the trump card. The AHJ can intervene. The AHJ has the authority to impose stricter guidelines or relaxed guidelines based upon circumstances. And in our scope, like what the code does, section 1.4 says, the authority having jurisdiction shall enforce and administer this code, and then all the 1123 that follows.
And am I correct that Captain Kokab was the AHJ in this case?
Yes.
And you're familiar, having read his deposition, with his training and background?
Yes.
Is it your professional opinion that Captain Kokab was qualified to serve as an AHJ in the fireworks display of July 4th, 2019?
Yes, I think he was qualified, eminently qualified.
Was there a point in time in your investigation where you actually traveled to the site of the fireworks display?
Yes,
And did you meet Captain Kokab there?
I did. I traveled, I met and interviewed Captain Kokab and the lead operator, Eric Johansson, and inspected the area, the site where the fireworks had been displayed previously.
And what was the purpose of that visit?
In general terms, to make sure that everybody's responses indicated to me the show was set up, permitted, and discharged according to code. There were no breaches. So I would ask about operation, observation, distance, location, type of materials, equipment used, et cetera.
And you had both the lead operator at that meeting, Eric Johansson, is that correct?
Yes,
And the AHJ, Captain Kokab, is that correct?
yes,
And you physically stood parking lot area where the display took place, is that correct?
Yes,
And in that area of display, you were able to observe the surrounding conditions, including the buildings that existed at the time of the fireworks display, is that fair?
yes, I was.
Were you provided information as to the distances from the display area to the buildings that existed in that area?
Yes,
And did you and Captain Kokab and Eric Johansson stand in that precise location where the fireworks display took place?
correct. They showed me exactly where the mortar racks that hold the fireworks were set up.
Okay. Were you provided an engineering report prepared by somebody by the name of Zachary J. Jason, dated August 7th of 2023?
Yes,
And did you have an opportunity to review it?
I did.
And did you formulate any opinions as to any of the conclusions made by Mr. Jason as set forth in his report?
Yes, I did.
Can we have page 35, please, Steve? And on this particular copy of the report, we have a paragraph that has been redacted. Is that okay?
Yes,
I'm going to ask you questions about other paragraphs here. I want you,
Which exhibit is this?
is this your exhibit? This is one of plaintiff's exhibits.
It is our exhibit, yeah.
My exhibit is not redacted.
Okay, I just want to note that for the record.
In our package, Your Honor, it is Exhibit 23.
Okay.
This is, Dr. Steinberg, this is Exhibit 23, which is a copy of Mr. Jason's report, which contains this redaction. So I just want you to familiarize yourself and ask, have you seen this particular report and this page before?
yes,
Were you able to read and review all of the conclusions that Mr. Jason made as a result of his evaluation of this case?
I was.
And did you formulate any opinions about those conclusions?
I did.
In the following answers to my questions, I would ask that you answer or provide those opinions to a reasonable degree of scientific certainty, okay?
Yes, I'm familiar with the standard.
Scientific and pyrotechnical engineering certainty, is that fair?
I think that's okay.
Okay. The first opinion is on the first conclusion I would ask you questions about is, Mr. Jason says, on July 4th, the newly installed TPO roof system on the Union Village Willoughby South campus was damaged by hazardous debris associated with the professional fireworks display being conducted by AFC in proximity to the subject complex. Did I read that correctly, as far as you know?
Yes, you read that correctly.
Okay. The next opinion is number 2. Based on the detailed site survey, the separation distances employed by AFC as part of the subject display on July 4th were drastically inadequate to what is required by the NFPA 1123. Did I read that correctly?
Yes,
Do you have an opinion as to that conclusion?
yes. Were you going to ask me an opinion about number 1 or just number 2?
Let's stick with number 2 at the moment. I may come back to number 1.
All right. First of all, I have 2 disagreements with that conclusion. Number 1, there is no separation distance required for unoccupied structures. The only separation distance required during a display is from the spectators, the audience. You know, there are subsets like during the setup, you can't have unescorted public within 100 feet. But with relevance to this case, there is no separation distance required for an unoccupied building.
Steve, can I have page 31?
And the second is the use of the word drastically. That's the kind of, it's subjective, but doesn't mean anything if there isn't any requirement to begin with.
When you were at the site with the AHJ and Eric Johansson, did you formulate an opinion as to whether the location of the display site in this case was or complied with relevant provisions of the NFPA?
Yes,
When you were actually standing there?
yes,
And what was it about the location that you believe complied with the NFPA?
I felt that, number one, for the size of the shells used, the separation distance from where the audience was met or exceeded the minimum standard. The separation is in proportion to the size of the shell. So like it's 70 feet per inch, so like if you shoot a 3-inch shell, you need 210 feet. So the first conclusion was from the positioning of the mortars to where the audience was viewing the display, the separation distance met or exceeded the requirements of NFPA 1123.
I wanted to show you this table 5 that is on Mr. Jason's report on page 32 of 36. Do you see this, this table?
Yes,
And
table 5.1.3.1.
Did you review this table as part of your evaluation of his conclusions?
Yes,
Okay. Interestingly, the table 5.1.3.1 deals with the minimum separation distances from spectators, right?
correct.
Does it involve in any way the separation distances from buildings?
No,
Did you happen to notice that the distances for outdoor area shell display sites, minimum separation distances from mortars to spectators for land or water displays in, can you take this back? I want to look at the original. Do you see how Mr. Jason bolded the words and then unbolded the section that says mortars to spectators?
yes, I see that.
Did you interpret that as a de-emphasis on the mortars to spectators attempt by Mr. Jason?
You know, I try not to get too exercised over that. I mean, if he's going to introduce it, we can read it no matter what the font is.
All right, well, can you explain what this distance for outdoor aerial shell displays from mortars to spectators means?
All right, so there are 3 things to understand about that table. Number 1 is the separation from the mortar to the closest spectator. And that's on a mortar by mortar basis. So like if you have different size, you can have your smaller mortars closer to the audience. It isn't like it's all one point. So that's the first thing to understand. The second thing to understand is that there's a whole column, sorry about that. There's a whole column there on angling. You can angle mortars for aesthetic, fill the sky more. And if you angle away from an audience, you can get closer. The other side's irrelevant because you're not allowed to angle fireworks toward the audience. The third issue is for the display site. You know, a lot of sites we know where the audience is. There's a well-demarcated area, but the display site has to have a radius of the separation distance. So, in other words, there could be people encroaching upon the site, so you want an area that's clear. You know, let's say during the show they move the audience because of wind or something. So you have 3 things: separation from the audience based on the mortar size, the ability to reduce that separation distance if you angle the mortars away from the audience, and the fact that your display site has to have a diameter 2 times the radius that encompasses essentially safe separation 360 degrees around the area where the fireworks are discharged.
Dr. Steinberg, if we assume, based on, well, we know, do we not, that the largest shells being used in this particular display were 6 inches, do you agree?
Yes.
How would that play into what the separation distances should be from the spectators?
From the spectators, that's 420 feet for a vertically placed mortar, or 1/3 offset if you angle away from the audience.
And from your evaluation of the facts and circumstances of this case and the testimony of witnesses, did the location of the fireworks display meet or exceed the minimal distances from mortars to spectators at that site that day?
Yes, it did.
Okay, thank you. And what would that be, by the way? We can do the math here, but what would the distance be with a 6-inch shell?
For the 6s, it would be 420 feet, and as previously noted, you could have the smaller mortars closer.
Okay, thank you. Let's go back to page 30. I'm sorry. Forgive me.
trying to find for you, Dr. Steinberg, the section that specifies the distance from unoccupied buildings. Give me a second here. Okay, I'm sorry, 31. There is an NFPA section that deals with or governs what distances should be from, or deals with the distances between the mortar shells and unoccupied buildings, is there not?
Perhaps you can
Well, let's
explain
look at
that further.
Section 5.1.4.6.
Thank you.
Okay. This is the code section that you referred to prior that indicates or discusses unoccupied buildings in the vicinity of fireworks displays, correct?
Correct, but you had said separation distances
Right.
when you were asking. That's what threw me off,
I'm
because
sorry, you're right.
that's not in there.
Okay, so what are the rules with respect to unoccupied buildings?
All right, number one, you can have dwellings, buildings, structures inside the display site, and the display site is that radius thing, 420 feet around the sixes, et cetera, with the approval of the AHJ and the owner of the dwelling, building, or structure. That's point one. Provided, point two, the structure is unoccupied, or if it provides protection for occupants through non-combustible or fire-resistant construction. 3. An example of that is sometimes we'll do shows on a parking deck next to an occupied building like a hotel, but if the fire marshal assures the windows are closed and the building affords protection, the building could be occupied. That's not relevant here, but those are the 3 conditions. You can have these things in the display site. You got to have the approval of the AHJ and owner. And if the structure is occupied, there has to be some protective measures from the structure.
Dr. Steinberg, on the day you visited the site and met with the AHJ and Eric Johansson, and you observed the location in the buildings, and based on your evaluation of the testimony and the evidence in this case, did American Fireworks Company have those items arranged or established such that these buildings could end up being in the display site?
Absolutely. Points 1 and 3, they're there, and they're unoccupied, as Fire Marshal Kokab, Captain Kokab noted. And number 2, obviously the fire marshal's there, so he's approving as the AHJ. And I was informed through the document review that the school officials were in meetings where it was discussed that the fireworks display would be performed. So we don't require written permission, but you can't just sneak up on people and surprise them.
Right. In all your review of the materials and the deposition testimonies and the communications and the reports, was there any indication that the East Lake Willoughby School District was not aware of this fireworks taking place on this date?
No, I mean in 3 ways. Number 1, it'd been done there a lot of times before. Number 2, they were part of the planning meeting process where this display was planned. And number 3, I understand there were people associated with the Willoughby East Lake School District who actually were in attendance at the display. So pretty much they knew.
There's something I wanted to point out to you about Mr. Jason's testimony that's not in his report, but I want you to address it nonetheless because he did mention it when he testified here this week. And that is down, Steve, down at section 5.1.5.2, fallout area. Where it's here. Now, I know you've reviewed his report, and the reference to this code section was not, or this NFPA section was not anywhere in his report, but nevertheless, he testified that this section has some relevance to the facts and circumstances of our case. And as you can see, it says fallout area. The fallout area should be in an open area. Spectators, unauthorized vehicles, watercraft, or readily combustible materials shall not be located within the fallout area during the display. Do you see that?
I do.
I will represent to you that Mr. Jason implied that the roofing material on top of that roof, the TPO roof, would qualify for readily combustible materials within the meaning of that section. Do you have any opinions on that, any such implication that Mr. Jason might have made?
object?
Yeah, I've got a couple.
Overruled.
Go ahead.
I have a couple of opinions. Number one, obviously, we're not worried about spectators' vehicles and watercraft. I think it's got to be the readily combustible materials that he's seizing on.
That was the implication.
Okay, so I object to that for 3 reasons. His saying that readily combustible material shall not be located within the fallout. Number one, during my authorship of this code, I actually wrote a section of code, chapter 6, section 7, 6.7. I do a lot of shows on the water, so we do them for marine craft, and chapter 6 refers to shows on barges and floating platforms. And the section 6.7 says you can't have readily combustible materials there. And we're talking about things like containers of gasoline, flammable liquids, paints, things like that. The other is, in the display, readily combustible means stuff that if a spark hits it, it's going to catch on fire. So when we do shows in fields, we want to make sure we're not going to start a grass fire. Readily combustible means if a spark hits it, it's going to catch on fire. And number 3 of 3, there was no fire on the roof. It can't be readily combustible if you don't have a fire. And personally, I'm not a roofing guy, but from my chemical knowledge of the material on the roof, this is not going to meet what I call readily combustible. It bursts into flame readily upon contact with a spark. So,
And we didn't have that here.
no, we didn't.
So the phrase readily combustible materials in this section is not defined, but you participated in actually defining that term in a different section, is that correct?
Correct. We have a section of definitions, chapter 3, and readily combustible and combustible is not, readily combustible is not a defined term. But having sat through a number of deliberations, it's, you can't define everything. You get to a point where it's common sense. Readily combustible means it catches on fire easily. Although we've had people debate what a flame is, so we don't know. But no, I don't find there was readily combustible material within the fallout area. I don't think the school roof meets the intent, at least from my participation, not speaking for the whole committee, of what we want to get out of the fallout area.
All right, thanks. Let's return back to page 35 and see if we can move further through the conclusions Mr. Jason made. Number 4, he opines that the separation distances employed by AFC should have been further increased per code due to the varying slope of the discharge location and the associated hazard mitigated. Did I read that correctly?
You did.
Did you formulate any opinions about that conclusion?
Yeah, yes, I did.
Or what are your thoughts and opinions about that?
Well, I try not to get upset about these things, but this is such a misinterpretation of code that this one bothered me. In other words, we've done all this stuff on angling. It's angling of the mortars. There is nothing in our code that ever, or in our notes or minutes or deliberations, that said distances need to be mitigated for a ground slope not being perfectly level. That is just, so from its premise, its initial read, you don't have any angling required for varying slope. If you did, show me the table. When I read that by Mr. Jason, I'm like, okay, well, what are you reading from? There's nothing in the code that says you got to angle for the varying slope. And the second part of the objection is there isn't any associated hazard to mitigate by angling the mortars that you're not required to do. It's just, to me, and I can't speak for anybody else's intentions, it's almost like the misreading is to a degree that I question how you get there.
And again, you were at the site of the display, and you were able to assess whatever varying slope there was from the surface, right?
Yeah, as a matter of fact, where the mortars were actually placed was more level than the hill a little bit up where the initial site diagram would have put them. That was by mutual agreement of the operator and the AHJ, and it was actually a fairly flat and level area where the mortars were placed. But even if it had been on the hill, there's just nothing in the code that says you got to angle this way or that way when your ground slopes.
Okay. That leads us into number 5, his conclusion number 5, if we can take a look at that. And there was testimony in this case that there was a change in location just prior to the fireworks display, and he claims that placed the subject complex directly within the fallout area of the fireworks display and created an extreme hazard, and was in direct violation of NFPA 1123 industry standards. Did I read that correctly?
You did.
And what are your opinions about that?
Three opinions. Number one, there wasn't any change to the site plan. You make adjustments. The show I did in 2024, July 4, fire marshals on site. We look where our mortars are, and we could maximize, we were compliant, we could maximize separation distance because we had crowd all around us, so we moved the mortars. That's not a revision of a site plan. That's at the time of the display, the operator and the AHJ decide, we could do this a little better. We're still within the site plan. Number two, which placed the subject complex directly within the fallout area. There's no problem with that. We beat that one to death. Who cares? It's an unoccupied structure that's not readily combustible. You can put it in the display area. So number three, it didn't create an extreme hazard or violate standards or code.
And you actually, when you were at that site, you were shown the original site area and then where it was moved closer. You saw both sites.
Correct.
And the reason it was moved closer was, I think you said, because it was a better, flatter location?
Yeah, it gave them a really nice level flat, which is easier for the operator. The problem with a sloped surface isn't so much angling of the mortars. It's, operator safety. It's easier to walk on level ground than a sloped ground. As long as your separation distances to the audience are compliant, you can make adjustments like that.
I want to talk about that for a minute because there's been testimony that, or implications in the testimony that the pyrotechnic operator is supposed to have the final location of the display set up days in advance and a plan submitted to the client so that everyone knows where the fireworks display is going to be. Is that your experience? Is that days in advance?
Categorically not. When you file a site plan in Maryland, we require 10 days notice. As long as you comply with the enforceable code, you can make last-minute adjustments. And I'll tell you, jurisdictions vary around the country, and some are very specific. Like in California, with your plan, you have to submit the exact number of shells and size, every firework device you're going to shoot. And even they don't require an exact location of every mortar so long as you're compliant with Cal Fire Code, which is different than NFPA but similar.
Is the purpose of the NFPA code to give the AHJ, the authority having jurisdiction, and the lead operator the flexibility to make adjustments once you get to the site to see what the site conditions are the day of the event?
So there are two purposes. Wearing my NFPA hat, the primary purpose is public safety.
Right.
Secondarily, we grant in the NFPA code discretion. 5.1.1, the AHJ has discretion to impose tighter restraints, to restrict some things, or to relax constraints if there are equivalent means provided or special circumstances. But yes, we do both things. Number one, that's primary goal is public safety. Number two, within the code, we give some discretion provided you don't breach number one and compromise public safety.
All right. Let's go to number 6, the conclusion he makes in number 6, and ask your opinion about that. He indicates that Eric Johansson was ultimately responsible for the overall safety regarding the setup and firing of the subject display. Let's start with that. Tell me about the interplay again between the operator and the AHJ on that day.
Yeah, it's interesting. Actually, I'm working in a case where the AHJ was injured and they're arguing over who enforces code. So having studied this issue at some length recently, the operator, and this is a defined term, the operator has primary responsibility for safety. That's the operator's number one duty, the safety of the crew, himself, people in attendance, the audience. Number two, the scope says the AHJ, the authority having jurisdiction, is responsible for enforcing the code, which, if complied with, will enable the operator to assure safety.
Let's go to number 7. It is alleged that multiple code violations and general failure to adhere to industry standards of care was the proximate cause for the accident. Can you give me your opinion about that statement made by Mr. Jason?
Yes, short and sweet. I didn't find a single code violation. I didn't find a single breach of industry standard, and I didn't find any necessary accident for which there needed to be a proximate cause.
Dr. Steinberg, have all your opinions that you've given thus far in this case been to a reasonable degree of scientific and pyrotechnical engineer standard of care?
Certainty, yes.
Certainty. Thank you. Thank you very much.
Mr. May?
Thank you, Your Honor. Switch over, thank you. Sorry, Dr. Stein, I'll be right with you. And sir, Dr. Steinberg, nice to see you again. Previously, we did not meet in person, and it's good to see you in person here. You recall our deposition previously?
Yes,
Sir? Yes? Did you review the transcript of that deposition?
Come on up. Go ahead, Mr. May.
Thank you, Your Honor. Dr. Steinberg, you issued a report in this case, is that right?
yes,
All righty. And I believe I've pulled it up here on the screen for us. Do you recognize the paragraph that I've highlighted here?
yes,
All right. You wrote this report in accordance with your engagement in this case, is that right?
yes,
All right. And incidentally, you are getting paid for your work in this case, aren't you?
yes,
You're getting paid $350 an hour, isn't that right?
yes,
Is that, and then for today, for trial, you have a $3,500 daily fee, isn't that true?
yes,
And you charge $3,500 for your deposition day, is that true?
correct. That's a minimum fee for appearance at trial or deposition.
And as of the time that you were deposed back, if we're a year ago, well, let me get that date here for you. But back when you were deposed in this case, as of December 18th, 2023, you had charged $15,000 before the deposition, isn't that true?
In preparation, I totaled up all the compensation received in this case, which I can simply review. I don't know like at which date, how much, but since the inception in August of 2023, I've been paid $30,500, which included $7,000 for the 2 days for the site visit, $3,500 for the deposition, $9,500 to block 4 days for this trial, and 30 hours of work.
All right. Well, let's talk about the report, which is how many pages? 4 pages? 5 pages?
Hold on a second.
Yeah, feel free to pull it up.
I have 7 pages here.
Okay. And we're looking here at this item 12. What page is that on?
I have it on page 6.
And you say there is no objective proof in evidence that either the damage to the roof was caused by fireworks to any degree that would require the roof to be replaced, or that such damage resulted from any breaches of applicable codes, regulations, and standards. What did you mean by no objective proof in evidence?
All right, so there are a couple of things on that. Number one, during the observation of the display, Captain CoCab, who was serving as spotter, didn't see any flaming debris come down. Now, after a fireworks show, there's a ton of burnt paper and cardboard and stuff, but it may not be glowing orange or on fire when it's falling. So I didn't see from that evidence any connection to the stuff on the roof being damaging. Number two, there was no fire on the roof. Number three, I never saw anybody hold up a section of the roof that showed that there was a hole burned in it. Number four, I'm aware that when Mr. Sorgai went up there, some of the pictures in the file show these white circles of a clean area that, you know, if you drop a burnt piece of paper on a white T-shirt, you'll get a smudge, but it's not a burn. That a lot of the stuff that I saw characterized as a burned area could well have just been a smudge that could be cleaned up. And finally, without going into reiterative detail, I think we've already been through, I don't find there any breaches of applicable code, regulation, or standard, so I don't think we need to rehash that. But I just haven't seen anything that shows me this fireworks display caused damage to the roof.
And I just want to be clear, when you made one visit, to Willoughby East Lake City Schools, correct? It was a 2-day trip, but you made one visit to the school, is that right?
That is correct.
Okay. And that was, you never saw the roof before it was replaced, before the membrane was replaced, is that correct?
That is correct.
All right. Now, you listed some items there that you're referring to here where you say no objective proof in evidence that either damage to the roof was caused by fireworks. And you mentioned discussion with Mr. CoCab. What about, did you do any further investigation, or were you provided any additional materials other than what you just told the jury? You based your conclusion of no objective proof and evidence of damage by fireworks to the roof.
I want to make sure I'm responsive to the question. I got a lot of materials. I got engineering reports, I got insurance investigator reports, et cetera. And I'm not a roofing expert, so, you know, I can understand that, okay, maybe there were some burned spots that would need to be patched or replaced, but that's outside of my area. You know, I'm not a roof guy. On the other hand, the statement I make, I don't have anything in evidence that tells me this fireworks display damaged the roof. And during my review of those photographs and documents and insurance reports, I never saw anybody simply hold up a piece of roofing and say, here's a hole burned through it. I saw a lot of paper, you know, and debris, you know, burned paper, and I saw smudges, but I cannot from the picture determine, and I wasn't on the roof, I can't determine if that's a smudge that could be wiped off, as Mr. Sorgai did on at least some of them, or it's a burn.
Okay, well, I just want to confirm for the jury, and you just said you're not a roof guy. So you're not pronouncing any opinion about whether this roof was warrantable following this firework display due to firework damage, or whether or not, according to roofing professionals, it required an overlay of the entire membrane over the disabled, underlying, burnt, damaged membrane from fireworks. You're not pronouncing an opinion on that, are you?
No, I'm not a roofing expert.
But you did say that there was no fire on the roof, didn't you?
I believe it was in Captain Kokap's testimony, no fire responder ever had to respond to a fire on the roof.
Okay, that's different from no fire on the roof, isn't it? If no first responder responded is different from no fire on the roof, isn't it?
I don't know that it is. You have a professional observer watching the display, and if there's flame or fire, you're going to see it. It's dark, it's night. And nobody in attendance at the display ever saw a fire on the roof. And in the examination afterwards, while there are spots, I've seen enough fires to say I don't see any place on the roof in the photographs where a fire, a process of combustion started. And indeed, if it were readily combustible, once it started, it would have spread. So I stand by the fact that I just don't see any evidence of fire ever happened on the roof.
And want to make one more clarification. You're not a certified fire investigator either, are you?
No.
Okay. So you don't pronounce opinions within a reasonable degree of fire investigative probability whether or not a fire occurred, do you?
I don't think we're getting far afield, but I'm not a fire investigator, but I've read Captain Kokap's testimony, his deposition, and he is an expert in fires. And further, Mr. Jason, who is a somewhat expert fire guy, show me a picture where there's a fire. We've all seen fires. I don't have to be a certified investigator to tell that's a fire.
Well, with all of your experience in launching fireworks displays and in the circles you move in, I know you're well aware of what a certified fire investigator is, aren't you?
Yes.
And you're aware that they go to school, they study fire investigations, and then if they achieve that, then they're able to be deemed a certified fire investigator. Then they get to offer opinions on that. All of that you're well familiar with, correct?
Well, that's two questions. One, I'm familiar with what CFIs are. When I worked for ATF for 8 years, our CES is our Certified Explosive Specialist. Some also held the dual certification in CFI, Certified Fire Investigator. So we kind of interact with each other with different areas of expertise. I'm aware of what CFIs are. And then allowed to give an opinion. Well, everybody has an opinion, but expert and give an opinion under oath to a reasonable degree of scientific certainty. I'm not going to say an origin and cause stuff, what caused the fire, but I'm going to hold it with my experience in pyrotechnics. I can tell if there's been a fire. Not going to opine how much it damaged the roof, but I'm going to tell you that I think I can look at the pictures and tell you, A, if there was a fire, and B, if it was in readily combustible material that spread.
Okay, so let's talk about that. So for you to pronounce an opinion here today before this jury that there's no fire on the roof, it would have been very helpful for you to know that a certified fire investigator was up on the roof when the damage was there, and that he pronounced an opinion and wrote a report about the fire on the roof. Would that be helpful for you to know before you come and testify and tell the jury under oath that there was no fire on the roof?
We said, would it be helpful? Number one, I'm aware of the report. Two, it's not helpful. Number three, if everybody agreed on what happened, we'd be in agreement, and we're not. And so I'll simply say I've read people who are competent like COCAB that say no fire. I've read your investigator said there's a fire. But I'm not a layperson, I'm not a CFI. But I don't find that the pictures I'm being shown by the CFI support or substantiate his expressed opinions. And as to the qualification, I'll let folks decide what is okay and what isn't, but that's my observation, that's my opinion.
All right, so what certified fire investigative report did you review?
I can't remember the fellow's name, Sorry about that.
Do you remember how experienced he is in fire investigation?
Oh, yeah, he had quite a nice resume.
Can you cite the jury what his opinions were?
Oh, you know, I remember reading his deposition transcript and his report, and his opinions are along two lines. One, the fireworks caused the damage, and number two, the roof, you know, was damaged by the fireworks.
Did you examine the photos of that investigator that are in evidence in this case?
I didn't hear the first part of
Have
it.
you examined that fire investigator's 140 photos documenting his investigation that are in evidence in this case?
Oh, yes, I've seen more than the 144 photos. There are a lot of photos in this case. I simply don't see them as supporting a fire on the roof. We're just going to fundamentally disagree on that one.
Well, you're fundamentally disagreeing with a certified fire investigator who actually investigated the roof before, at the time that it was damaged.
Objection, Your Honor.
Aren't you?
Overruled.
Yeah, that's pretty much exactly right. Like I say, I'm not a qualified CFI. I'm not a layperson. I'm experienced in pyrotechnics. I've seen a lot of pyrotechnic-related fires and burns, and I have the fellow's report, and he's certainly qualified to offer that opinion, and I see the photographs he offers in substantiation, and I just don't find them convincing. But again, that's my opinion, so the answer is yes, I disagree.
All right. That's, yeah. That's not right. All right, it's right there. Oh, got it. Thank you. My computer shut down and it wouldn't recognize my face. I'm not used to putting in my password. I apologize. All right, Dr. Steinberg, so you're under oath contradicting, taking a position other than a certified CFI who actually did the investigation. Have you been here throughout the trial, Dr. Steinberg?
Well, number one, you misstated my testimony. Okay, so I want to get this straight that no, I didn't contradict him. That would be offering an alternative opinion. I want to be very precise and clear. I'm not contradicting him. It's outside of my scope. I'm telling you that I'm not a layperson. I don't agree with him. I'm not offering a qualified expert CFI level opinion. I'm simply saying I'm a little bit better trained than a layperson. I've seen his report. I've seen the photographs. And I don't understand how if there's a fire on a readily combustible surface, the fire doesn't take hold and spread. I disagree with him. I'm not convinced. I'm not contradicting him or offering an alternative opinion.
That's actually not true, Dr. Steinberg.
All
You
right,
said
listen,
no
listen,
fire on the
listen,
roof.
Listen, we've had a number of questions, and he's given the answer, and we've gone back and forth, so let's move on from there.
Thank you, Your Honor. Further, with regard to the, where you are indicating in your report that there is no objective evidence caused by fireworks, are you aware of the testimony of Adam Searcy, who testified in this case?
Of
Adam Searcy, a roofing inspector who was hired by Sedgwick Insurance Company on behalf of American Fireworks. Are you familiar with his report in this case?
I believe I've seen that as well.
Are you aware that he's testified in this case?
No, the latter part of your previous question that got cut off was, have you been in attendance during the entire week and seen the whole trial? And the answer was no.
All right. So does it affect or change your opinion to know that Mr. Searcy, who is a qualified roofing expert, testified that that membrane had to be replaced due to burn damage on the roof?
That requires me to offer an opinion regarding the necessity of replacement first, secondary to burn damage second. And I'm not going to offer a roofing opinion.
Okay, good. But doesn't that play into your statement in your report that there's no objective evidence that the membrane needed to be replaced or that there was roof damage?
No, because objective means, like you say, hold up a picture of a hole burned in the plastic. That's objective. Preserve a piece of it. You know, they could have saved chunks of it. That would be objective as a thing, an object. What I'm dealing with is I don't see anything but conflicting opinions or interpretations. And those are opinions, and they have weight, but I'm using the word objective to mean related to like an object. Like, could you cut out if you cut out a piece of it and show it to me, say, do you think this is a burn hole? I'll give you an opinion.
So you don't have a piece. Our pictures are objective evidence, aren't they, Dr. Steinberg?
But the photos fail to show evidence of a fire to me, or holding it up to the light to show penetration. They show black marks, but I can't tell from the pictures if there's smudges that can be cleaned up because dirty burnt paper landed on a nice whitish color membrane, or there are holes burned through it. And again, with the conflicting CFI guys, I'll let them determine whether the roof needed to be replaced or there was a fire. But my opinion is as expressed. Nobody's convinced me there was a fire, and I'll yield on whether the roof needs to be replaced or not. There's plenty of other people that can address that.
You said conflicting CFIs, other than the Mr. Strader's report that you reviewed. Who would be the other conflicting CFI, since you're alluding to that?
Well, none. You're telling me there's a CFI who says there's a fire. There's a CFI who says the roof needs to be replaced. There are two. But again, if they say there was a fire on the roof, I have two problems with that. Number one, I've interpreted a lot of stuff, not CFI qualified, but people have shown me, hey, this was a fire and here's our evidence. And I'm either convinced or I'm not. I'm not convinced here. You know, the second is no one produced an object. So, and of course, as to whether or not the roof could be patched, repaired, or needs to be replaced, that's beyond my scope.
So those aren't, there's no CFI other than Mr. Strader who is in evidence in this case. So as far, you see no conflict there, agreed?
Yeah, you know, I had thought by implication you were telling me there were two CFIs, but if they are one and the same, then it would be hard for somebody to conflict with himself.
Are you aware of another CFI?
No, I'm not.
Okay.
I was misreading your line of questioning.
All right, then. Are you aware of another roofer who contradicts Adam Searcy's opinions?
Objection, Your Honor, can we approach?
Yeah.
as part of your materials, did you review a report of Ken Handsome in this case?
Ken Hanscom?
Handsome.
Yes, I believe I reviewed that.
Okay, who was Mr. Handsome?
You have to give me some more information. Again, I reviewed a number of documents, but if you have a specific question, fine. Off the top of my head, I can't recall.
Sure, I'll
Mr.
help you
Hansom's
and
stuff.
refresh your recollection.
Appreciate that.
Mr. Handsome is a construction consultant hired by Travelers Insurance Company to go up on the roof and evaluate the damages.
Thank you.
You're welcome. Do you recall reviewing his report?
Yes,
Okay. And then you recall that Mr. Handsome indicated that on his evaluation that the entire roof membrane had to be replaced.
yes.
All right. I think you talked, did you review the estimate of a Brandon Paul from Commercial Roofing and Coating Systems?
I did. As a matter of fact, there was one estimate initially. They gave a figure of over $2 million, and then it came back down to considerably less.
Excellent recollection on that, Dr. Steinberg.
It's like pulling a loose thread. Give me a clue, and I'll drag it out.
So then Mr. Paul also was in line with Mr. Handsome, who was in line with Mr. Searcy as far as your understanding and investigation, correct?
Yeah, but rather than give a blanket in line, it's my recollection that all three agreed the roof needed to be replaced and that they came to an agreement on the dollar value, about $1.25 million.
And at any time were you given a cost estimate drawn up by Adjuster Jim Ellis in this case?
Yeah, I believe there was an initial cost estimate. I can't remember who authored it. It came in at $2 million and change, and then the parties collaborated, and it came down to roughly $1.25 million. I can't remember who did each estimate.
All right, now, we talked about all that evidence. All that evidence seems to be in line with each other and dovetail. Is there any conflicting evidence that I haven't brought up about damage to the roof that gives you the question and pause to conclude that this roof was burned and damaged?
Yeah.
Okay, what's the conflict?
I think the people just referenced got off on the wrong foot, by assuming the fireworks display damaged the roof and then took it from there. And there are times when multiple experts get involved in a case. I don't know how to illustrate this without an example. A plane that straps fireworks on, there's a fire that crashes into a house. And all the aviation people say the fireworks couldn't have exploded because they were in an aluminum housing, was open, it wouldn't have built up pressure. They called me and I said, no, you don't understand the device. It's a tube. It exploded, that ruptured the fuel bladder. I said, I'll explain the firework part, and what happens after that with the aircraft fire and the crash, that's out of my league. But you guys don't understand fireworks, you don't know what the cause was. And I think these folks are, again, qualified as roofing people, and I'm not going there. But within my scope, was there a breach of code in the operation of the display? And to the best of my scientific pyrotechnic certainty, was there debris or material from the display that caused damage to the roof? I disagree. I don't think there was.
Okay, so in your view, Mr. Ellis, who after a 40-year career in claims adjusting, who's retiring after this week, got off on the wrong foot and just went down the wrong path and paid $1 million, in your opinion, correct?
It misspeaks, what I'm thinking. I'm thinking that they see a roof they think is damaged, they see a fireworks display, they made an initial conclusion. It's like, doing a criminal investigation when you focus on the wrong suspect, or a medical diagnosis where you jump to a conclusion. And I disagree with their assessment. Again, I'm not a roofing expert, but I've read the various opinions, including Mayor Fiala's opinion that, guys, you could have fixed this for a lot less money. That's not my area. But was there burning fireworks debris that started a fire on the roof? Nobody has shown me something that convinces me there was such a problem.
Truth be told, Dr. Steinberg, you can't, you have to contradict all of those reports and all of those experts. You have to contradict them because you know under the code, NFPA 1123, that if you admit that there's fire on the roof, if you admit that there are burn holes in the roof, if you admit that that membrane had to be replaced because of the firework damage, then it's defined as hazardous debris, and that means American Fireworks Company breached the code. That's why you are contradicting this mound of evidence without a shred of contrary evidence. Isn't that true, Dr. Stein?
That is so far from the truth that I'm almost at a loss as to how to respond, but I will. All right, let's take apart that hodgepodge. Number one, let's go back to the fireworks display it's shooting off. Let's go to number two, hazardous debris, which is a defined term. You know, I've been in attendance at probably 1,000 fireworks displays and been lead operator on 125. And I understand Captain COCAB. Let's take a look at hazardous debris. When you see stuff falling from the sky, it's either glowing orange or it's not. And against a black sky, it's invisible. And Captain COCAB is qualified, so rather than take the tail and swing the dog around, let's take a look at the dog and work our way to the tail. I'm going to tell you there was no hazardous debris in my interview with Eric Johansson and Captain COCAB because it's visible. And you're not liking that. You know, you're equally determined to go the other way. There's there's no hazardous.
Hey, hold on. Just no opinion, no editorializing, okay? Just give your answer, okay? Thank you.
I'm convinced no one saw hazardous debris. It would have been glowing. Therefore, what follows is there's no breach of NFPA code that requires the cessation of operation of the display or relocation. Now we're past, now we start bringing in roofing people. You go up on the roof after the show, what do you find, what do you argue? But the mouthful that you asked me to agree with is so far from my opinion.
Okay. So you're allowing your interview with Mr. COCAB and Mr. Johansson, an interview that you did, to outweigh all of these reports, all of these certifications, all of these many decades of professional experience in roofing and adjusting, but that's all overweighed because you talked to Mr. COCAB and Mr. Johansson for about how long a piece? 10 minutes a piece?
That is very much in error. It's a nice set of words, but I don't agree. Now, why don't I agree? Let's walk through it again. Number one, I've observed a lot of fireworks displays. You know, I can ask you in one question what color your car is. If you tell me it's green and I see it's green, I don't need to spend an hour discussing the various shades of green. I know what hazardous debris is. I've helped write the code. I've observed more than 1,000 displays, and I've led 125 of them. I don't need but the time spent in the interview with Captain COCAB and Eric Johansson to determine they complied with the code. There was no evidence of hazardous debris falling on that roof during the show, period. Number 2 of 2. It's not a long list. When I'm numbering, I always like to let people know how far we are from the end. Number 2 of 2. I've also seen the fields after over 1,000 fireworks display. And I know what the cardboard and the burnt stuff and the debris looks like. And that's what I see on the roof. Ergo, I'm not getting into the hyperbole of getting rid of decades of experience and qualified investigators and, you know, et cetera. I'm simply telling you I am convinced firmly, based on my experience, my knowledge, my participation in the display fireworks industry, there was no hazardous debris, no breach of code, and the photos I've seen are consistent with debris that would have been invisible because it was extinguished and it wasn't hazardous.
How long did you talk with Mr. COCAB?
I believe I was on site for a few hours, and I spent probably a half hour to 40 minutes each talking with COCAB and Johansson.
Did you make any recordings of that discussion?
No, I did not.
Okay. Do you have any notes of that discussion?
No, I did not take contemporaneous notes.
And if it isn't okay for American Fireworks to rain down fire on the Willoughby East Lake City Schools membrane, is it?
I don't know how to respond to that because I've already stated, again, this is very similar to how we enter. It's the same material. No, they didn't rain fire down, but if they did rain fire on the school roof, that would be hazardous debris, which would be glowing and you'd see it. And the fire marshal, the fire captain would say, whoa, fire's raining down in the sky. It glows, you can see it. And he'd have stopped the display.
Are you aware that there was water infiltration, that the membrane leaked like a sieve after the fireworks display, and that there was interior damage and many, many ceiling tiles that had to be replaced because of the water that came
Objection.
through?
Objection, Your Honor.
Sustained.
Were you aware of any water damage to the interior of the building?
No, I'm sorry, I misread that traffic. Was that an objection sustained or?
Yeah, this is another question. You can answer that question.
Thank you.
Thank you.
Yes, I read the reports about water damage and tiles being replaced.
So you knew that that membrane was adequately damaged to cause leaking through the roof then?
Objection.
Isn't that true?
Overruled.
Okay, I know that there were problems with the roof, but I don't see the connection to the fireworks. And in reading the various reports, two comments struck me, not that I'm a roofing guy, but one was about the grading that allowed water to pool. And I was interested in the discussion between the roofing folks that allowed water to pool, which could have breached the defense of the roof that proper grading, or as they indicated, would eliminate. You wouldn't have pooled water. Number two, in terms of the installation, in particular, Mayor Fiala's opinion, the installation of flashing, which had nothing to do with the fireworks, and the HVAC penetration may also have not met standard. But that's the roofing guy. So bottom line, I'm aware there was water penetration and damage to roofing tiles, ceiling tiles, but I'm not aware of any convincing or, how should I say this, consensus agreement among the roofing people that it was the fireworks that did it.
The fact that it was paid under the claim by a 40-year experienced adjuster under the claim for damage from the fireworks, is that meaningful to you, and would you defer to the experienced adjuster in that determination?
Absolutely not. Now, I'll sort of explain that. Number one, this investigator, the adjuster, who initially ascribed liability to the firework, is utterly inexperienced in terms of his the investigator, her, the adjuster, interpretation of fireworks code. That's what put a pause on this thing. I will not yield to say that person knows how to analyze fireworks-related damage better than I do. That's why I get called into these cases. A lot of times people say, it looks like X, Y, or Z. Can you help us figure out what fireworks do, have done, or allegedly did? So no, I don't say, oh, well, the adjuster says pay it, so everybody can go home now. No, I don't yield to that.
Thank you. This picture that I brought up, which is Plaintiff's Exhibit 17, have you seen this before?
I have.
Okay. What would you say is in this picture here?
Assuming magnification verifies it, it looks like debris from a fireworks show, burnt pieces of paper, stuff from fireworks. And you can see there's some kind of an angle there where water pools in a linear form. So I can see it's a roof. It's not completely smooth, but I'm not a roof inspector. And it looks to be covered with littered with fireworks debris and have some pools of water.
Well, with your experience, I am happy to hear the concurrence that this is firework debris, and you've already testified you're very well qualified to recognize this as being such. Do you know the circumstances under which that photo was taken?
I don't recall it off the top of my head, no. I don't have a date on there, et cetera.
Okay, I'll represent to you that this was taken by the roofing contractor when he discovered this condition and took these in a panic to text them to the school district superintendent to indicate there was an emergency up on the roof. And we can see, as far as you can see, we see an even spread of a total covering, in fact, of this membrane. Would you agree with that?
Overruled.
Would you agree with that, Dr. Steinberg? I mean, I see it, there's no place.
Hold on.
I'm sorry.
Let me answer that.
Sorry,
Go
Your
ahead,
Honor.
Doctor.
Thank you.
Could you repeat the question you want me to agree with?
Yeah, I'm seeing this field. Do you see any area in here that's not covered with firework remains and debris?
Yes.
Okay. Where?
There's more of the roof that is not covered with debris than is. The debris is discrete chunks. I'd say it probably occupies 5 to 10% of the surface. But I think where you're going is it uniformly spread over the entire visible roof surface. The answer is yes, it's uniformly spread, but it doesn't cover the whole roof.
You're right, that was my question. It was based on the photograph. But you indicated big chunks, and I'll grant you big chunks. There are big chunks here. But Dr. Steinberg, I don't know if you've looked very closely at this photograph, but there are many, many, if thousands upon thousands of little charred marks in this photograph. Thousands upon thousands. You're aware of that, right?
No.
You weren't aware of that.
You said charred marks.
Well,
I'm aware that the fireworks material is charred because it exploded, it blew up, it burned up in the sky, and then it fell. But what I'm not aware of is that there are charring areas on the roof underneath of these things, which had they been on fire would have been visible. Won't go through the whole thing there, but they fell to the ground. And indeed, this is very much what it looks like after a fireworks display. There are thousands of pieces of cardboard and clay and string and other types of debris which are not on fire when they're falling.
What else is there, Dr. Steinberg, besides cardboard? Firework is not merely and only composed of cardboard, is it?
Is your question generally about fireworks composition or construction?
Yeah, that is.
Okay, so the shell, the fireworks shell, has fuses and charges that push it up in the air and make it burst open in the sky, and things in it that produce colors and effects, and casings, which are typically cardboard, paper, string, things like that, sometimes clay.
Thank you. Now, let's scroll through the photos, because you mentioned that, oh, this is only one view. If we scroll through, we're going to see a couple stop. We're looking at a different roof, entirely different roof. Have you seen this picture before?
I have.
And did you also on this picture conclude that the markings on this brand new white membrane are fireworks remains?
You said markings. Do you mean the objects, the
The
things?
things that aren't white, that in the pictures are depicted as black spots or brown chunks.
Yes, that looks like fireworks debris.
Okay, thank you. And we keep going here. Thank you. And this is yet another level of the roof. And have you seen this picture?
Yes.
And also, same question, apparently firework remains or debris. Would you agree?
Yes.
All right, thank you. And then back up to the top because we skipped that one, top. Yep, keep going. Yep, all the way. Thank you. This gives us a little orientation there with the football field. Have you looked at that picture as well?
Yes.
All right. And that's also firework remains, in your opinion, correct?
Correct.
All right. And then, so you've launched many, many fireworks displays yourself, correct, Dr. Steinberg?
Yes.
All right. And scroll down to the next one. Thank you. And Dr. Steinberg, you don't think American Fireworks did anything wrong in this case, is that right?
I agree completely.
All right. I know you think that, or you're testifying that. So if you finish a display, and you know this is a brand-new $1 million membrane on a brand-new building that's getting ready to open to bring kids in for the school year, in your opinion, this is what you call compliance, isn't it? It's what you call code compliance.
Yeah, I feel like I have to respond to that because I've done so many shows in so many areas. You know, sometimes a sponsor, you know, one in Bethesda, Maryland, they wanted every piece of cardboard picked up. I mean, we were there till like 3 in the morning. You know, it was in the city square. Other sponsors say, we'll get some people in the field to come by with a lawn vac, or we'll get some people up on the roof with a leaf blower, and we'll blow it away. You know, we always tell them if you find anything that's other than burnt paper, you know, if anything that you have a question about, let us know, we'll come inspect, because we don't want any live material that could hurt somebody to be around. But yes, that is absolutely what you see after a fireworks show. And if the, you know, the school said, hey, can you guys come up here with some lawn blowers and get rid of this and, you know, clean it up, fine. If not, I do a lot of fireworks displays where the site itself, whether it's a rooftop, a parking garage, or a field, where they come by in the morning and they do the cleanup, baseball fields. A lot of times they prefer to do their own cleanup management than to have the fireworks crew do it. You asked the question, are they compliant? And the answer is 100% yes, because there's code that regulates how you do a display. They're compliant with it. And there isn't anything in code that says you have to go up on every roof and clean up every piece of cardboard afterwards. But you could certainly consider it if the sponsor asked you to clean up.
So
It varies.
you as a pyrotechnical launcher who finishes your display and does this to a brand-new membrane roof, you're proud of your work that day. Is that right?
Sustained.
But I should answer.
Hold on, no, you should not answer.
Do you think that if that kind of situation is left on an owner's new membrane roof, that they should be notified by the firework company?
I don't know I can answer you yes or no, so I'll try and explain it. If it's not responsive, you tell me and we'll try it again. Number one, if I had done the display that went off according to Hoyle, I'd be totally proud of it. Number two, I would expect if I went up on the roof that the roof would look like the roof looks. There's a whole lot of paper and debris. Number three, I'd be perfectly amenable if the sponsor the next day said, hey, we're working on the roof, can you come up here and clean this up? I'd do it. You know, if they'd asked me ahead of time, listen, after the show, would you go up on the roof and clean it? I would. But during the show, if I'm not notified that there's any evidence of a hazard by my spotter, Captain CoCab, then I have no reason to go on the roof, and I probably wouldn't have gone up on the roof.
Thank you, Dr. Steinberg. I have no further questions at this time.
Any redirect?
Very brief. Dr. Steinberg, consistent with what you just testified to, I'll start where they ended. It would not surprise you to learn that the city of Willoughby, the sponsor, had an agreement with the school district, having done these shows every year for 20 years, that they typically send a crew out the next day to clean up the school board site from any fireworks display that they found. Would you be surprised to learn that?
Not at all. That's usually the way we do this. I mean, the local people come by, inert material, and clean up.
And in fact, the next day, a day or two after this fireworks display, representatives of the city of Willoughby actually went up on the roof, like you said, with a leaf blower and did blow much of the debris away. Would that surprise you?
Not at all. That'd be pretty much consistent with how we do things.
Okay, so if this building wasn't there, where would this debris be found then?
parking lots, fields.
Okay. Doctor, again, all of the opinions you gave in this case were to a reasonable degree of scientific and pyrotechnical engineering certainty. Is that fair?
Yes.
Thank you.
Recross.
Nothing further, Your Honor.
All right, you may step down, sir, thank you. All right, ladies and gentlemen, we'll take our lunch break. Remember not to discuss the case among yourselves or with anybody else. Don't try to look for any information from any other source, and do not come to any conclusion until the case is submitted to you. We'll start at 1 o'clock. Okay, anything else for the record?
Nothing for the record, Your Honor.
Thank you, Your Honor.
Okay, next witness.
Thank you, Your Honor. Defense calls Richard Peter Crayley.
You raise your right hand, please. Swear testimony about gives the truth, the whole truth, and nothing but the true self you got.
I do. Your Honor, can I approach the witness stand?
Yep.
Can we some other things?
Mr. Crayley, make sure you stay close to that mic, okay?
Okay.
Mr. Crayley, will you please state your full name for the jury, please?
Richard Peter Crayley.
And Mr. Crayley, what is your occupation?
I'm an architect.
And what is the name of the business that you operate?
Crayley Consulting, Inc.
What is your education background, please?
Attended the University of Cincinnati School of Architecture from 1972, graduated in 1978, and then attended Cleveland State University to obtain a master's degree in 1980.
And are you a licensed architect in the state of Ohio?
Yes,
And how long have you been licensed?
44 years.
All right. As part of your licensure process, are you required to take continuing architectural education?
Yes,
How often do you do that?
every year.
Okay. And describe for the jury work history after becoming an architect.
When I graduated, I joined a firm called Tufts and Wenzel. We designed hospitals in Northeast Ohio. After that, I joined a firm called Braun and Spice, and we also designed hospitals, where I left there in 1994. I was a partner. Since then, I've been on my own. When I immediately left, I was designing small buildings, and then about 20 years ago, I pretty much stopped designing buildings and started doing investigations and research and assisting attorneys in matters like this.
Are you licensed in any other state other than Ohio?
Yes,
How many other states? Or I'm sorry, what other states?
Pennsylvania, West Virginia, Kentucky, and Nevada.
Do you have any experience, work history experience, or consulting experience with matters or construction matters involving thermoplastic membrane roofs?
Yes.
Can you describe for the jury what your experience is in that area?
The first building I designed out of school in 1978 had a thermoplastic roof on it, but it was made in Europe because in that time they weren't made in the United States, so we had one specifically shipped over to put on that building. Since that time, I've investigated several thermoplastic roofs for a variety of clients. Most of the times they're leaking or failing, and I had to come up with solutions to remedy those situations.
Have you been asked to design repairs or fixes for, can we call them TPO roofs?
TPO, yes.
Okay, it's a rubber membrane roof, right?
Plastic, yes.
Okay. Have you been retained to design fixes or repairs for TPA roof membranes?
From time to time, my assignment does include that, yes.
Okay. Have you testified in any litigated cases involving TPO roofs?
I don't know if those went to a trial or not, no, I can't recall.
But have you been retained as an expert to evaluate construction-related issues involving TPO cases?
Yes.
On how many occasions could you estimate?
Over the past 35 years, it could be at least 20 or 30. I don't have an exact count in my head.
Okay. You were retained in my office to become involved in this case as a consultant, is that correct?
Correct.
Do you remember when you were retained?
Not the exact date, but it would have been springtime of 2023.
Can we have Q? And can you describe for the jury, what was the subject matter of your retention? What were you retained to do?
I was informed that there had been some fireworks that had landed on a roof in Willoughby, and there was a concern about repair versus replacement. And by the time I was retained, the roof had been replaced. And I was asked to take a look at it and say, was that a valid and reasonable resolution to the problem, or were there other solutions available?
Did I provide you with some background and documentation relating to this dispute?
Yes, you did.
And after your evaluation and your review, did you produce a report that you provided to me which contained a summary of your opinions in this case?
Yes.
You provided more than one, is that
Correct.
the case? Can you recall any of the items or the documents that I provided to you and asked you to review?
Well, I have a list of 50 on the first 3 pages of my report, but it includes deposition transcripts, contracts, reports, emails, manufacturer's literature. It's a whole litany of items.
Okay. And did you ask to go see the site of the fireworks display?
Yes.
Okay. And when did you make that site visit?
I believe I was on the roof August 22nd, 2023.
All right. And who else was at that site visit along with yourself, if you recall?
There were representatives of the school, and Mr. May was also with me.
Okay. And when you were up on the Mr. May, Mr. Doug May here?
Yes.
Okay. When you were up on the roof, did you take some pictures?
Yes, I did.
Okay. And what were you doing on the roof? What did you want to do on the roof when you were there? What were you there to see?
Well, it's my understanding, maybe this is a time to bring that roof plan over to,
Okay.
Let's do that.
or you could just turn it around and I could describe to you what.
Sorry, we're having technical difficulties.
Go ahead.
May I approach the
Yeah, sure.
exhibit?
Yes, yes. Describe to the jury what it is that you looked at and what did you see?
We entered onto the roof to take a look at a couple things.
Make sure you're keeping your voice up, okay? All right.
Took a look at a couple things. First of all, this is a metal roof, we're not looking at that. These are the TPO roofs on top of the building. This one, and this one were replaced. These were the original ones that were not replaced. So I wanted to see what the replacement roofs look like, as well as the original roofs before replacement, compared to quality of the two.
Okay. All right, thank you. As part of your evaluation of this case, did I provide you with photographs of what appeared to be firework debris on the roof of this building?
Yes,
No, I can't see it. Did I also provide to you documentation from Johns Manville and reports as to the evaluation of the damages claimed in this case?
Yes.
That were alleged to have been caused by fireworks
yes,
damage.
yes.
Okay, Your Honor, can we have 1 minute, please? We need just a second, Your Honor, if that's okay.
Are you gonna use this again?
Yes.
Okay. Just wanna make sure that Mr. Traub isn't blocked out from seeing.
No,
all
I
this.
will try not to do that. I'm trying to find a better place to put it. Maybe over here.
You could put it here.
Oh, yeah, we're gonna do that. Mr. Crayley, just while we're waiting, I just want to ask you some detailed questions that don't specifically relate to this. But this roof diagram, have you ever seen a diagram of the roof that showed or demonstrated exactly where these photographs showing these dots or alleged damage from fireworks were sort of spread out?
No, none of the photographs have captions to tell you when they were taken, by whom they were taken, where they were located, and what they supposedly show.
So what did you see? You saw a collection of photographs, and what did those photographs show?
They showed black marks, and we don't know if the black marks were caused by the fireworks or somebody scuffing from their shoe. It's my understanding people were up there with shovels and brooms trying to clean up the debris, and the corner of the shovel may have dug into the material. We don't know.
Had you ever seen a diagram showing where the damage on the roof was?
No.
Had you ever seen any samples of roofing materials that were allegedly burned?
No.
So is it your understanding that, did anybody during the repair or replacement part of this case. Thank you. Okay. It was a close one, I have to admit. Do you know whether anybody retained any samples of the roofing materials that they claim was burned due to fireworks?
It's my understanding they weren't retained.
And you never saw anything like that?
Never did, no.
Okay, so now we're at your report. Anyway, back to the documents you reviewed. You listed them in your report dated September 6th, is that correct? Beginning with 1, and
Correct.
let's look at 2. Page 2. Okay. Again, the list of everything that you've seen, including photographs, invoices, Johns Manville reports.
Correct.
Did you become familiar with an individual by the name of Bill Runyon?
Yes.
And who is Bill Runyon as far as you know?
He's the John Mansville representative who dealt with this project.
All right. Did you have an opportunity to review his deposition?
Yes.
Did you ever have an opportunity to speak with him?
Yes.
All right. Under what circumstances did you speak with him?
To gain some information about this roof.
Did you call him yourself?
Yes.
Okay. Did you review any reports that he published?
Yes.
Okay. Now, Steve, if I say to you, I want you to go to Exhibit F, what are you gonna say to me? Okay, all right. Mr. Cranley, have you seen this document we marked as Exhibit F?
Yes.
Okay, do you know what this document is?
It's one of 4 site visit assessment reports created by Bill Runyon.
Okay. And the date of the report is July 6th of 2019, correct?
July 16th, yes.
16th, I'm sorry.
Yes.
So that's about 2 weeks after the 4th of July fireworks that give rise to this dispute?
Correct.
Okay. And you read this report, and you looked at the photographs that were attached?
Correct.
Okay. Can you explain to the jury what your understanding of what Mr. Runyon was trying to convey here in this report? From your experience as an architect involved in construction of TPA roof systems.
It's confusing what he wrote, but I tried to understand it. What I think he meant was to take out a 10-foot by 10-foot area, take off the material on top, take off the protection board underneath, put new protection board on, and do something by putting another layer on top. A 10-foot by 10-foot area is probably the area in front of the floor right here, 10 feet by 10 feet, 100 square feet. And he lists in this report allegedly 11 areas that he's proposing that.
And he describes it on the first page as areas of damage due to the fireworks, is that correct?
Correct.
Does he specify, could you translate where from his report onto the topographical map of the roof where he was talking, where these items were located?
No, he didn't specifically show a roof plan and show specifically where he was talking about it. It's a little bit, it's a little confusing because I can't really tell what he's talking about. Plus, he doesn't identify how many hits or how many burns or dots are in each area. Is it 1, is it 2, is it 10? We don't know.
Okay. There's been some testimony in this case that what he was actually saying is he wanted to somehow disable, was the word that he used, disable the roof, meaning more or less replacing it?
It appeared to be, yes.
Okay, do you know what that means?
I've never heard the word disable when it comes to roofing.
Okay. As your reading of that report, though, does that report seem to indicate that he's recommending the replacement of the roof?
Not the entire roof, just of certain areas.
What areas?
Those 11 areas that he's talking about on pages 1 and 2.
And what is the total square footage of the area of the roof that he was concerned with in this report?
It appears to be 1,100 square feet.
Okay. So I'm going to refer you to Exhibit G then. Oh, and by the way, he doesn't mention anything in this report of Exhibit F about the warranty, any problems with the warranty? Doesn't
No, no.
And then you've seen Exhibit F then, I assume?
Correct.
Okay, what is Exhibit F? No,
Talk
I'm sorry.
about G?
G, we need G.
Is that the July 29th report?
Yes.
Okay.
Yes.
It's a second report that he prepared, again, inspection, and he went through and listed more areas to repair this time.
Okay. And again, the report indicates that he's focusing on areas of damage due to fireworks, does it not?
Correct.
But again, he doesn't identify where in the entire roof system, 3 roof system, he's talking about in terms of finding alleged fireworks damage, correct?
Correct, and he doesn't tell the number of hits or number of dots from fireworks.
Okay, so reading his report, you would be unable to point to that roof plaque and identify where the items he's describing were located.
Specifically, no.
And none of the photographs you reviewed would do that either.
Correct.
Is that right?
Correct.
And what is he recommending be done here in these 18 areas?
He's increased it from 11 to 18 areas, of, again, taking out a 10-foot by 10-foot area and replacing the membrane.
Okay. What's the total square footage involved there?
Now we're up to 1,800 square feet.
Do you interpret the language being used in this report in any way suggesting that the entire roof membrane be, the entire roof membrane of the entire roof system be torn off and replaced?
No.
Does he mention anything about how this repair that he's suggesting would affect the warranty on the roof?
No.
Do you know whether or not Bill Runyon ever recommended that the roof be torn off and replaced completely?
I'm not aware that he did.
Okay. But he never told you that, right?
Correct.
All right. Are you aware of who made the decision? I'm sorry, jumping ahead of myself. All right, so let's move now to Exhibit H. Have you seen Exhibit H before?
Is that the August?
Yeah.
The email, yes.
Yeah.
Yes.
You've seen that email?
Yes, I have.
And I'll represent, this is an email between the manufacturer's rep and the Johns Manville personnel indicating that they're gonna get to sell the job twice.
Yes. Yes.
You've seen that?
Yes.
And that's what you understand that email to be saying?
Yes.
Okay, so, in your experience being involved in TPA roof systems, both the manufacturer and the manufacturer's rep gain additional profit from selling a job twice, do they not?
Yes.
Okay, and that date of that is, email is August 1st of 2020, or 2019, is that right?
Correct.
In this email, Mr. Day, the author, says, unfortunately, that upon inspection of the JM inspector, Bill Runyon, it was reported to the construction manager that the system was not warrantable. Did I read that correctly?
Yes.
Okay, but we didn't see that in either of his reports.
Correct.
Is that correct?
Correct.
All right. Have you ever come to learn the reason why Mr. Runyon apparently is deciding now to not warrant the repair request, the repair recommendation?
It's my understanding he was saying because of the firework hits, he couldn't warrant the roof as is in its present condition with the fireworks exposed to the air. That doesn't take into consideration doing repairs. Once it's repaired, then it becomes warrantable again.
Were you aware of what his position, Mr. Runyon's position was, if the repairs he recommended in the 18 areas described in Exhibit G, are you aware of what his position would have been originally with respect to those areas and the repair he recommended?
I believe it would have been warrantable.
Did he testify to that effect?
I don't recall from his deposition. Yes, in his deposition he did, sorry. In his deposition he did say if the roof was repaired, it would be warrantable, yes.
Okay. So do you have any explanation as to why apparently he's no longer, as of August 1st, indicating it's warrantable?
Sustained.
Have you read anything or been provided information as to what explains the reason that as of August 1st, 2019, Mr. Runyon is no longer willing to warrant the repair he recommended?
Well, again, he didn't want to warrant it due to the alleged damages. And it's my understanding that the decision to replace it was made by other people.
Okay. Let's look at Exhibit J, please. Have you seen Exhibit J before?
And that's the August 20th?
Yes.
Okay, yes.
Have you read Exhibit J as part of your evaluation in this case?
Yes.
Okay. What do you understand Mr. Runyon's recommendations now? to
Well,
be?
well, again, on page 2 of that, he goes back to cutting out the 10 by 10 areas. So it's sort of confusing as to what he wrote here, because someone could interpret it as repairing the roof, someone could interpret it as replacing the roof. It's sort of like he's straddling both sides of the fence.
Okay, he's not being particularly clear?
No.
Okay. Have you ever seen a report prepared by Bill Runyon that indicates definitively that he recommends replacing the entire roof?
No.
Okay. Now, the observations you've made of the conditions he's described, do you have an opinion as to what an appropriate repair might have been for these items that these 18 items that Mr. Runyon had identified in his July 29th report?
Yes.
And to a reasonable degree of architectural certainty, what would you have recommended be done to those areas in order to properly repair them?
Had it been up to me, I would have recommended repairing the roofs with patches.
And what kind of patches?
There's different kind of patches. It depends upon how many dots there are, hits, and how close together they are. If it's one single one, and you've seen a lot of photos of one single hit between Tuesday when I was here. If it's one single hit, these are standard size patches. This isn't the material, this is just the size. Standard size patches that all the TPO manufacturers, including John Mansfield, makes. So if it's as big as my finger, this would cover it easily every time there's a patch. If there were many holes or many dots in one area, say there's 10 of them concentrated in a piece of paper like this, someone would cut a larger patch. So the patches can be any size, but they would cover all the burn marks, sealed around the edges, and it would be as good as new.
Would it help if I gave you a pen and let you diagram what a proposal might be?
I could do, yeah, sure. I have one actually here.
Oh, you do?
Sure.
Can you do it on the back of it? Yeah.
If we take a 10-foot by 10-foot area, and we put dots here, each one could be covered with one of the patches I just showed you. But if we put a lot of dots here, we would take a patch this large and cover it, wherever there are dots on the roof. We haven't been told how many of these hits actually occurred. It appears from Mr. Runyon's reports, there were 18. There may have been more, but nobody documented them. That was the first problem. Had I been on the roof, I would have documented each and every one and would have shown it to you. On this plan, I would have said there's 4 here, 2 here, 1 here. Whatever it would have been over these roofing areas, we would have a plan view. And then we'd have a course of action as to, are we using patches this big, patches this big, or patches this big? They all work. They would be put on top, they would be heat welded, and the roof would be good as new. It would cost a fraction of $1.3 million, and it was repairable.
Do you know whether or not it would be appropriate to use that patching system in a Johns Manville TPO roof such as this?
Yes, because this roof that I went on, the day I went on the roof was specifically to look at how the new roofs were put on and how the existing roof was put on. I went through and counted this area, this area, this area, and this area. There's over 800 of these patches that put on the roof, and the roofs were warranted. And then there's several more this size, and there's several more larger ones, all different size patches. There's easily over 1,000 patches on this roof if you were to actually count every single one. I stopped at 800. I thought, this is enough.
You're talking about the new roof.
Both the new roofs and the old roof.
Let's go to Exhibit O, please. You said you photographed the new roof.
Correct.
Okay. O. Exhibit O. Okay, let's move to the photographs. Again, these are photographs that you yourself took on the roof of the day you visited in August of 2023.
Correct.
In addition to the patches we're going to look at, did you observe what you believe to be substandard installation work with respect to this roof?
Yes, both on the existing and the new.
Okay. Go ahead and describe what we're seeing in photograph A and B.
Everywhere you see a brown area, that meant that water ponded or sat in there. There was a depression in the roof. And when the water evaporated, it left behind that debris. In the wintertime, when water ponds and sits there, it freezes and turns into a sheet of ice. And as the ice expands, it will cut into the membrane and cause damages or leaks. So it's very unprofessional and unwanted to have those ponds or depressions. That is, go ahead.
Go ahead.
That is repairable, but they shouldn't be there.
Do you see patches in the photograph in Exhibit B?
There's patches in every photograph. I think I provided in my reports.
Let's page through the photographs so we're not spending too much time on that. Okay, Exhibit C and D, are you seeing patches?
Yes, C patches in the top and D at the bottom, several patches.
And this is the existing roof as it is today?
Yes,
Okay, let's keep going, Steve. E, F, you see patches?
yes,
H, you see patches?
yes. There are patches everywhere, yes. Now, if we stop for a minute and look at G, and then there's another photograph farther in my report. We show the parapet wall. The part that's sticking up is called a parapet. Along the parapet walls, there are a lot of patches. That's where the two materials come into each other, so they had to seal all the corners and joints. If you were to go down that line, you would see many, many, many patches. Some small, some large, but a lot of patches along the edges.
What could be causing the need for these patches,
Object.
if you know?
Overruled.
Well, when you put a patch down that has sort of a square corner, you're worried that the corner over time is going to lift up. So what they did was they put a circle over the top. That has no corners to it, so that will hold down the corner below. So everywhere there's a corner, they sealed it. Or everywhere two pieces came together, they sealed it with one of these. That's why there's 800 of these or more on the roof.
Well, there's been testimony in this case that the reason that Runyon ultimately or eventually refused to say the warranty or the guarantee would apply with that because the fix he was suggesting would provide too many patches on the roof. Is there, in your opinion, is there any validity to that contention?
It's not valid because, as I said, there's over 800 on the roof already, and no one has come forward and said there were more than 800 hits on the roof. For all we know, there's a fraction of that. But if we added 10, 20, 30, it's a small percentage of 800.
Let's continue to look through the photographs that you took. We're at Exhibit H. Let's move forward, Steve. Keep moving. Okay, what do we see here in Exhibits O and P?
This is on the existing roof that's an unfinished edge. It allows water to come into the building. I'm shocked that this still remained in the day I was there.
Have you seen any Johns Manville warranty reports that point out these particular defects that you yourself observed?
No, I'm not aware of any, no.
Okay. And you aware of who the contractor was that did the replacement work?
I believe it's commercial roofing.
Is that the same contractor that did the original work?
Correct.
Okay. Go ahead, let's proceed. What are you seeing in photograph R?
And again, the top and bottom photograph with the green arrows are pointing to areas of ponding. I think the top one actually is water sitting there. The bottom one is where water was coming out of the HVAC equipment, but again, ponding, and that's not a desirable situation to have on a roof.
Brandon Paul testified yesterday that in looking at these photographs, he thought that was typical of any TPO roof, the ponding and the stains. Do you agree with that?
It shouldn't be. It shouldn't be, no. A properly installed roof drains towards the drain, so water is not sitting on the roof.
Okay. Go ahead, let's proceed further. Keep going. Keep going. In Exhibit X, what do you see there?
Both Y and X again show areas where water had ponded. The interesting part of both of these photographs is that water is actually ponding around the roof drains, meaning the water can't reach the roof drain. The elevation of the roof is higher than the drain, so the water can't get inside of it, so it just sits there and evaporates.
Brandon Paul testified that when looking at these photographs, he thought that the mechanical contractors had moved the equipment on him, and therefore he had no responsibility for that condition because it was the mechanical contractors.
Somebody has a responsibility. I mean, either the mechanical contractor or the roofing contractor, but the owner needs to get somebody out there to fix that.
And in your opinion, it should not remain in that condition?
Not at all, no.
And this is a roof, as far as you know, that Johns Manville warrantied. Is that correct?
Correct.
Okay, let's go, let's proceed. Oh, keep going. Okay, what are we seeing with this vertical stack in AA?
Both AA and BB show several patches. In AA, we see 1, 2, 3, 4, 5, 6 or 7 patches in an area, 2 feet by 3 feet. BB, we're showing 1, 2, 3, 4, 5, 6, 7 patches in an area probably as long as this table and as wide as this table. A lot of patches.
Okay, let's proceed. Keep going, Steve. Keep going. What is Exhibit FF?
Again, a lot of patches around that roof hatch coming up around the edges because they don't want, again, they don't want the material to curl up at the edges. So they put a roof patch over the top to stop that from happening.
Okay, go ahead and proceed, Steve. H, is there any particular concern with that condition depicted in Exhibit H?
Again, GG and HH show a lot of patches within a short period of space, a short distance of space. And again, they're used to seal down there. It's an acceptable way to install and seal the roof.
Okay. All right, let's proceed. Okay, go ahead. Go ahead, Steve. Go ahead. Exhibit PP and OO, what are these depicting? Again, ponding and patching?
Again, dark areas where there's ponding, and in the foreground of PP, 1, 2, 3, 4, 5 patches.
Okay, let's proceed. R looks problematic. I'm sorry, is R a problematic condition in terms of patch overlapping seams?
No, again, QQ and RR show many patches, and for some reason, the contractor decided to put patch on top of patch on top of patch, and Johns Manville elected to warrant that condition.
Okay. Let's go, next one.
That might be it.
Okay. Having reviewed the condition of the roof that exists right now, per your inspection in August of 2023, and having reviewed the Johns Manville reports that describe, the July 29th report that described the 18 areas of concern from Johns Manville then, is there any reason why you can think of that the patching recommendations that were made by Bill Runyon on July 29th, coming 2029, could not result in a legitimate warranty being issued by Johns Manville?
No, it's my belief what Bill Runyon proposed would have worked, and even my solutions, even less costly and less evasive, would have also worked, but the roof could have been patched easily.
Do you have an opinion as to how much time and material it would have taken to effectuate the repairs that Bill Runyon was suggesting in July of 2019?
Yes, his 1,800 square feet times $13 a square foot, which is the cost of what it cost to put the roofs back on the building, would have been about $25,000, plus or minus.
All right, so Bill Runyon was effectively recommending a $25,000 fix, is that right?
Correct.
All right, and he initially indicated he would warranty that fix until somehow he changed his mind, is that
Correct.
right?
Correct.
Okay. And you observed a roof that was replaced with patching far more extensively than that which Runyon was recommending, correct?
Correct.
And Johns Manville warranted that roof, is that correct?
Correct.
Okay. In your evaluation, were you able to did you look at any data that showed you the condition of the original roof before it had been replaced?
I saw some photographs that were taken, and you've seen those photographs too, and they show a lot of patches. So the existing roof, before they repaired, had patches, as do the existing roofs that exist in the back of the building have a lot of patches.
Do you know Bob Fiala?
Yes, I do.
All right, did you evaluate Mr. Fiala's report?
Yes.
Okay, let's have Exhibit K. And by the way, what do you know about Mr. Fiala's education and background?
He's an architect just like I am. We're a similar age, and we go back knowing each other probably 50 years almost.
You met him here today?
Again today, yes.
All right, when was the last time you met Bob today?
could be 30 or 40 years ago. We saw each other, we worked together on some committees.
You did not speak to Mr. Fiala prior to today about this case, correct?
Not at all, no.
Okay. So none of your opinions are based on anything you and Mr. Fiala discussed?
No.
Okay. But you reviewed his report, here it's Exhibit K, dated October 11th, 2023, correct?
Correct.
Did you look at the photographs that are contained in this report?
Yes.
Can we see these photographs? Can you tell what's being depicted in Exhibits 1 and 2 on your own without reading Mr. Fiala's explanation for it?
I didn't put my contacts in today, so I really am having trouble seeing.
You can't see that?
No, it's pretty
What if I
fuzzy.
gave the report to you?
That might help.
That might help? Okay.
I'm sorry.
Yeah, it's okay. You don't need cheaters?
No, cheaters wouldn't help today.
I'm sorry, Your Honor, approach the witness. I already did it, I apologize, Your Honor. In his report, Mr. Fiala identifies Exhibits 1 and 2, indicating water discharging onto the roof membrane in construction scene. Do you see that?
Yes, I do. Yes,
See that? Do
yes,
you agree with that assessment?
yes.
Do you have anything to add to it?
No, the stains indicate that there's water coming out of the equipment, and you want the water to find its way to a drain, and it appears that it's not all finding its way because there are stains remaining on the roof.
Do you know what positive drainage is?
Yes,
What is positive drainage?
from a high part to a low part to enter into the drain.
Okay. And is it the roofer's obligation to establish positive drainage towards a roof drain?
Yes.
Objection, may we approach, Your Honor?
Yeah.
Mr. Crayley, getting back to the original subject matter, it's your opinion, your professional opinion, that the system suggested by Mr. Runyon in his July 29th, 2019 repair report would have in fact effectively addressed the problems he described allegedly caused by fireworks?
Yes,
And whether it was that system or the system you suggested, that condition could have been repaired?
yes,
And that condition could have been repaired in a manner that any manufacturer would have issued a warranty for?
yes,
And you had indicated that the cost associated with what Mr. Runyon was suggesting would have been about $13 per square foot,
correct.
and that would total how much?
Approximately $25,000.
Okay. And would the manner in which you had suggested the repair, would that have been more expensive or less expensive?
Much less.
Okay. Well, for today, let's just stick with what Mr. Runyon is recommending.
Okay.
Have all your opinions been to a reasonable degree of architectural certainty?
Yes.
Okay, thank you very much, Mr. Crayley.
All right, cross-examination.
Yes, Your Honor. Sorry, Your Honor, I'm trying to get this exhibit here.
Mr. Crayley, it's good to see you again.
Good to see you.
We first met, I think, about 20 years ago. You were working for Jim Glowacki on the Busaith case. You remember that?
I don't remember it.
All righty. You're testifying today as an architect. 100% of your professional work is dedicated toward matters in litigation. Isn't that right?
Today, yes.
Okay. And that's been the case for about 20 years for you now?
Correct.
Is that right?
Correct. Do you hear me? Okay, sorry.
Yeah.
Yes.
Thank you. I appreciate that. So it's been 20 years since you've designed a building, correct? Professionally.
Correct.
All right. And in fact, you've actually worked for Mr. Fogarty here a dozen times at least as a forensic architect. Isn't that right?
Correct.
So maybe this is your 12th or so case with Mr. Fogarty, right?
It may be, yes.
All right. Good repeat customer here, I guess.
Let's strike that editorial comment, ignore that. Come on.
Yes, Your Honor. I'll move on. What are you getting paid here for your testimony today?
When I testify, it's $550 per hour.
And you did that in this case already in a deposition, is that right?
Correct.
Is that correct?
Correct.
All right. What's your invoices, what's the total invoicing that you have to date on this matter?
I couldn't tell you. I don't have that number in my head.
Is it more than $20,000?
It might be, I just don't remember.
And it's true, Mr. Crayley, that you've never designed a building that has a TPO membrane roof. Isn't that true?
Well, I told you the first building I designed was a hybrid TPO.
What year was that?
That was in 1978.
Hybrid TPO, what is that?
Well, it was before it was called TPO, but it was a plastic roof that came from Switzerland.
So it wasn't called TPO, is that right?
Back then, no.
TPO wasn't even around then, was it?
Didn't come into play it's the 1990s.
All right, so when you said earlier that you had designed a building with TPO, that wasn't correct, was it? That wasn't accurate, was it?
No, but that roof that I designed in 1978 was, for all intents and purposes, a TPO membrane. It looked like it smelled like it bent like it, and it performed like it.
All right. Again, you've never designed a building with a TPO membrane, have you?
Not the one that was called TPO.
And your answer is?
Not one that was called TPO. We can do this all day.
And you've
Well,
never?
look, let's not do this all day.
No, I don't want to.
Okay? Then let him ask a question, you answer the question.
Okay.
If I think it's gone too far, then I'll stop it, okay? So
Sorry, Your Honor.
let's do it that way, and we're not gonna have any more editorial comments, because we've talked about this a number of times in the last 4 days, so let's get on with it. Go.
You've never purchased a TPO membrane, is that correct? Mr.
No,
Crayley?
I don't purchase TPOs, no.
Okay, and you've never supervised the installation of a TPO membrane, is that
Never
correct?
supervised the installation, no.
Okay. You've never even observed the installation of a TPO membrane, have you?
No.
And when you've testified as an expert like you are here today, you've been involved in less than 5 matters involving TPO membranes. Isn't that true?
I couldn't tell you how many.
All right, in this case, you made one site visit in support of your investigation and the opinions you're expressing here today. Isn't that right?
Correct. Correct.
And that site visit was on August 22nd, 2023.
Correct.
You never saw the installation before the firework damage that you've testified about here today, did you?
Correct.
You're going off of other people's photos, isn't that correct?
Correct.
And your opinions differ than the people that actually took the photos. Isn't that true?
They may.
And then you also never saw the roof when it was in its burned condition prior to it being repaired, did you?
Other than the photographs, no.
So you relied on other people's photographs, and American Fireworks didn't invite you to go with them when they visited the roof on August 20th of 2019, did they?
I don't know who they had representing them at that time, but no.
All right, you testified about Mr. Runyon's reports, which I hope we can bring up here. And you've got them in front of you, I believe, in defendant's exhibits here, beginning at, I believe, tab F, is that correct, in front of you?
Yes.
Okay. I'll refer you to these reports, and we'll, you indicated in your testimony that you said that Mr. Runyon's reports, what he wrote was confusing, but you tried to understand them. Is that right?
Correct.
Okay. Well, would you agree that Mr. Runyon's reports are internal reports that go to Johns Manville in the capacity that he serves in as one of their field investigators?
I don't know that for a fact, no.
Okay. So there might be a reason that you might not understand them because they are not for public consumption, they're for internal consumption. Does that ring true to you? Just your knowledge of the industry, you know that, right?
No, I'm not aware of that, no.
Okay. Well, let's see if maybe we can together, maybe we can get a better understanding of them. And by the way, speaking of understanding them, were you here when Mr. Runyon himself sat on the stand and attempted to explain them
No.
to the defendant? All right. I think we can understand them, and they actually fall together really clearly once you put it all together. So let's look at them here.
Come on up.
Oh, sorry. Can we scroll down, please? Let's just stop there. Thank you. Was this one of the reports that you reviewed, Mr. Crayley?
No.
So did you know that Mr. Runyon made visits to the roof before the fireworks occurred?
I believe I was aware of that, yes.
Did you review either of the two reports that he authored of his visits to the membrane installation before the fireworks?
I only have the four in my report, which you're aware of. I don't have any. I didn't have that report.
All right, so scroll to the next report, please. All right, this report is dated May 28th, 2019. In progress, Mr. Runyon report, did you review that report?
I don't have that report either, no.
Are you aware whether or not this roof was slated to be warranted as of this date, this date here, May 28th, 2019?
No, I'm understanding that there was a warranty inspection process, but I didn't, I wasn't aware of that it had been warranted yet.
Okay. If we scroll through that. Okay, stop there. Looking at these photos, 1.7, 1.8, does that look like that roof appears to be ready for warranty?
I can't tell from those photographs.
All right.
I would need to be on the roof.
Okay, let's go forward then. Next report. July 16th, this one you did review, correct?
Yes, if we could actually go back to that prior report, I have a comment about some of those photographs.
Yeah, he had a punch list on there, which was in progress, and he testified about that.
Well, the extensive number of wrinkles would be of high concern to me. All those photographs showing wrinkles in the membrane.
Are you aware of the expansion process of this membrane material and what the expectations are of expansion in the first couple years of practice and the temperature variations?
I would not expect it to wrinkle that much. No, this is an adhered roof. It should not be wrinkling that much. It goes to show that it's not adhered properly to the substrate.
Okay. Were you here when Brandon Paul testified in this case?
No.
Okay. If Brandon Paul, who is a commercial roofing and coating systems owner who operates the company and has installed these on a continual basis for 10 years, testified that that expansion is normal, would you defer to him on that?
No, I would not defer to him on that, no.
All right, then. We'll go on. July 16th, you did review this, correct?
Correct.
All right. Why don't we scroll down? Okay. Just go back up one more time. All right, so you indicated you were not familiar with disabling a roof, is that right?
I've never heard the term disabling a roof in 44 years, no.
Well, I mean, you're not in roofing, right?
I've inspected a lot of roofs, and I've read a lot of literature, and I've never come across the word disabled when it comes to a roof, no.
You've inspected less than 5 TPOs in your forensic practice and never installed a TPO, is that right?
I've inspected a lot of roofs, and I've never heard the word disabled.
Okay. Well, if I were to tell you that that Bill Runyon, who has been an inspector for Johns Manville, who manufactures TPOs, and he's done that for 40 years, and that is a term of art that he uses, would you agree that that's a term of art in the industry?
No, it may be a term he uses, but I would not subscribe to a term of the industry, no.
All right, and okay, I'll grant that. So then he does list out these items, and this is probably the confusing part, I'm guessing, to you, is where he lists these out, and he talks about these existing cut the field membrane and a 10 by 10 grid removing 1-inch strips. What does that mean? How did you interpret that?
I can't tell if he's telling us to take out a 10-foot by 10 area or 1-inch strips within a 10-foot by 10 area. The English is not very clear.
All right. Well, if I told you that he and Brandon Paul both seem to understand this term and that they both describe it as a checkerboard, that they're cutting into the existing membrane across the entire roof surface in order to create drainage gutters so they can overlay the next membrane level,
Supposed to be sloped roofs, very slightly sloped, but another layer would not stop the water from reaching the drain. But to cut out 1-inch strips, no.
No, the concern was that they would have water trapped between those two membranes. If they just took, because the first one was destroyed by the fireworks, if they just overlaid without cutting these strips, they would create pockets of water. That was their concern, and that's why they called out those 1-inch strips across the surface of the old membrane.
Is that a question?
Does that help in any way?
No, the membrane was not destroyed by the fireworks. A dot here and a dot here does not destroy the fireworks. You put a layer on top and you seal the edges the same way they sealed all the other 800 seals. The water is not going to find its way underneath. That is ridiculous if that's what they meant. I mean, it truly does not comply with any industry standards I'm aware of.
So you disagree with Mr. Paul?
I
and you
disagree.
with Mr. Runyon and how they assess TPO membranes under your authority, is that right?
Yes.
Okay. And then you said just now that that the roof wasn't that damaged. That's what you're indicating there?
There's no indication that it was that damaged, no.
All right. Well, you did review in your report, you have the report of Adam Searcy, correct?
Yes.
Okay, he was, and you indicate and you note in your report that Mr. Searcy was retained by Sedgwick on behalf of American Fireworks. Is that right?
I believe so.
All right. And you also note in your report that Mr. Searcy came to the conclusion that the entire membrane needed to be replaced. Is that right?
Yes. Yes.
You also, as part of your report, reviewed the report of Kent Hansen, who is a construction consultant. You reviewed that as well, correct?
Correct.
And you acknowledged that Mr. Hansen also called for total replacement of the roof. Is that correct?
Correct.
You also reviewed the report of Brandon of Commercial Roofing and Coating Systems and Brandon Paul, his company. Is that correct?
Correct. Correct.
And Mr. Paul, well, it was Taylor Shaw at that time, and Mr. Paul also recommended taking off the membrane, replacing the membrane.
You're saying that the contractor that put on the first roof is recommending tearing it off and putting it on the second roof?
Well, just like every other expert that I just cited, yes.
And you don't see that as a conflict of interest?
Listen, you don't ask him questions,
Okay,
you
okay,
answer his
okay.
questions, okay?
I see that as a conflict of interest, but yes, he did say that.
Well, okay, then we'd still be left with Hansen and Searcy, right?
Correct.
Okay. So as far as you know, every roofing contractor or specialist who's looked at that roof after the burns concluded that the membrane had to be replaced, as far as you know. Is that fair to say?
As far as I know, but I didn't see in any of the reports that they even considered repair options.
But you are judging them yourself without having viewed the roof prior to it being replaced.
I reviewed all the photographs that were provided.
And those were photographs they took. Plus, they were up there, but you're pronouncing your opinion over their own. Is that right?
Correct.
Okay, thank you.
All right, redirect.
Yeah, very, very quickly, Your Honor, thanks.
That Mr. Searcy had a theory that he discussed in his report as to what was the basis for his reasoning and concluding that the roof needed to replace. Had something to do with 10 patches within 10 something? I'm sorry, I don't remember. Do you remember?
The 10-patch theory, yes.
What is the 10-patch theory?
Mr. Siri was promoting the fact that, if I can draw a photograph.
Yeah.
Mr. Siri was saying that if you have 2, 3, 4, 5, 6, 7, 8, 9, 10, if you have 10 dots, you can put a patch over each of them, and that's okay. As soon as you have 11th dot, have to replace the roof. That's his theory. I don't know how 10 was the magic number that he came up with, but it's not recorded in any Johns Manville
Okay,
literature.
let me
Oh,
ask
go
a
ahead.
question.
Okay.
That 10 theory, have you researched any manuals or industry standards to see if that theory is recognized in any way by anyone, any manufacturer?
Yes, I've researched not only John Mansville, but there are 7 major TPO roofing manufacturers in the country, and I researched all 7, including John Mansville.
Can you name them?
Yes, I can.
Objection, may we approach?
Yep.
Mr. Curley, I'm sorry, can you name the manufacturers?
Yes, there's 7 manufacturers. These are the primary manufacturers of TPO roofing. GAF Everguard, Carlisle Sherweld, Genflex EZ, Elevate Ultraply, Johns Mansville, Versico Versaweld, and Mulehide.
And when you gathered an understanding about what Mr. Searcy was saying in his report about the theory that led to his conclusion the roof needed to be replaced, did you see that recognized in any of the industry standards or any of the manufacturers' standards?
None of their standards recommend any prohibition on more than 10 patches. Their warranties don't talk about it. It's silent, and Johns Mansville actually admitted to me it is not a written policy, so it's not a policy. Plus, there are manufacturers of these patches that I just showed you a few minutes ago. These manufacturers actually have websites, and on their websites, you can buy 100 of these patches for $90, and nowhere on this site does it tell you you can't put more than 10 in a certain area. And then I went through individually each one of these. It doesn't show up anywhere. There is no industry standard about limiting you to 10 patches within 100 square feet.
Then, when you went to look at the roof as it exists today, in August of 2023, did you observe that very condition of 10 patches within 10?
Yes, well, first of all, Mr. Searcy in his report actually saw 18, so it's already over the number. But
I'm sorry, 18 in what?
in the, I believe the existing roof.
Okay.
When I was there that day, this is a new roof right down here. And it's a parapet wall. And my photographs show that if you go to an area 50 feet long, 2 feet wide, which is still 100 square feet, you are going to see 20, 30 patches within that area right there. So the new roof easily exceeded the 10 patch theory that Mr. Searcy's talking about.
So if you were to take Mr. Searcy's theory as to when a roof needs to be replaced, the roof as it exists right now would need to be replaced, is that what you're saying?
Or would never have been warranted by Johns Manville, according to that condition that I'm talking about.
Thank you. Mr. Crilly, this is not the first case you and I have worked on, is that correct?
No.
This is also not the first case that you've been involved with Travelers Insurance, is that a fact?
Correct.
Have you been retained by Travelers Insurance in the past?
Since the years 2002 to 2020, I've worked on 87 cases for Travelers Insurance.
Okay. Thank you, Mr. Crilly.
You're welcome.
May?
Yes, thank you, Your Honor. You were not here for Mr. Searcy's testimony, correct?
Yes, I was.
Oh, you were here?
Yes.
Okay, well, did you hear when he testified emphatically that the reason that he determined that the membrane had to be fully replaced was because of, not because of the warranty, but because of the damage that he observed. Do you recall that?
I believe he may have mentioned that, yes.
Well, he held to that under vigorous cross-examination, is what my recollection is.
All right,
but
listen.
You recall,
Look,
thank you.
No. Your recollection doesn't matter. You can ask Mr. Crayley a question.
Thank you, Your Honor. Mr. Crayley, that's all I have. Thank you.
Thank you. You may step down.
Thank you.
All right, come on up here a minute, please. All right, we're going to take our break. Remember not to discuss the case. Don't look for other information. Don't come to any conclusion. And please, swear testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God. Thank you. All right, have a seat. Keep that microphone close, please.
Mr. Fiala, thank you for being here. As you know, my name is Dennis Fogarty, and I represent the American Fireworks Company. I thank you for your time being here. I would like to ask you, what is your current occupation?
Mayor of the City of Willoughby.
Okay. And how long have you been the mayor?
This is my 8th year.
Okay. And as a city official, have you been involved in the planning of fireworks events for 4th of July, or so, things like that?
For the City of Willoughby, yes.
Okay. And are you familiar with American Fireworks Company?
Yes,
And are you familiar with Mr. Robert Sorgai?
yes.
Do you know how many years the city of Willoughby has had a relationship with American Fireworks?
At least 20 years that I know.
Okay. And during those 20 years, in your interaction, from your observation, your interaction, do you consider American Fireworks Company to be a reliable company?
Yes, I do.
Have they always delivered the product that the city purchased in a professional way?
Yes,
As the city, have they always come through and successfully put on fireworks displays for the city?
yes.
Have you ever, other than the matter we're here to talk about, has there ever been any complications or problems with the work done by American Fireworks Company?
No,
To your knowledge, other than the matter we're here to talk about today, has American Fireworks ever been responsible for damaging any city property?
not to my knowledge, no.
Okay. And is American Fireworks still the vendor that the city goes to for fireworks displays?
Yes,
Okay. So this July 4th of 2025, American Fireworks will be putting on the Willoughby fireworks again.
yes.
Okay. I wanted to talk a little bit about your background. Prior to becoming mayor, or I shouldn't say prior, but in your private life, what was your profession?
I'm an architect.
Okay. And how long have you been an architect?
Registered architect for 45 years.
Okay. And what is a little bit about your education background?
Bachelor of Architecture degree from the University of Notre Dame and a Master's of Urban Design from the University of Southern California.
Okay. And when did you first become licensed in the state of Ohio?
1980.
Okay. And where have you, let's talk about your work history after becoming a licensed architect in Ohio.
My first job was in 1977, prior to being registered. Over those years, I've worked at 3 different firms, 30 of those years for TDA Architecture. The prior jobs were with Houston Associates in 1977, and then about 11 years at Richard Obone and Associates.
Okay. And in all your professional time as an architect, have you been involved in the construction and design of commercial buildings?
Some commercial buildings, yes.
Specifically, school buildings?
Yes.
How much of your career was spent being involved in the design and construction of school buildings?
At Houston Associates, which I spent about 5 years, 98% of their projects were public education, K through 12. And then at TDA, about 85% of their work is public education, K through 12.
And how many years did you work for TDA?
30 years,
Oh, you actually are a part owner of the company?
yes.
Okay.
I'm no longer employed there.
Okay. And those educational buildings, did they frequently have flat roofs?
Yes,
Did you have occasion to work with, I'm sorry, let me rephrase the question. Did you have occasion to become involved in the design of flat roof systems for school buildings?
yes,
Are you familiar with the term TPO?
yes.
Okay, what does TPO stand for?
It's a thermoplastic polyethylene or something like that. It's a roof that has twin plastic membranes, and in between them is a reinforcing mesh.
Okay. And have you been involved in selecting TPO roof systems for the designs that you were involved in for school buildings?
Yes, I have.
Have you been involved in observing the installation of those roof systems?
Yes, I have.
Have you been involved in dealing with manufacturer reps of that product and part of the construction process?
Yes,
Have you worked with Johns Manville individuals for TPO roofs?
I'm sure I have, yes.
Okay. So you're qualified, based on your education and experience, to evaluate and assess the quality of an installation of a TPO roof system on a school?
I think I am, yes.
Okay. About how many projects, is there an objection?
Yes. Yeah.
Overruled.
About how many, if you can estimate, school buildings were you involved in evaluating the installation of a TPO roof system in your career?
I would say about 100 school districts.
Okay, all right. And the roof system involved in the Willoughby East Lake school system is, that was recently constructed in 2018, 2019, that included a delivered TPA roof system, did it not?
Yes.
How did you come to learn that?
I learned of it actually subsequent to the fire, the July 4th event.
Okay, you didn't know, you were aware, were you aware of that construction project, the YMCA and the senior center?
Yes, just no knowledge of specific construction techniques or design.
Okay. And in 2019, how long had you been the mayor of Willoughby?
2019 was my second year as mayor,
Second year, first term?
first term.
Okay. Were you involved in negotiating the contracts with American Fireworks Company to provide the fireworks services that year?
Yes, I signed the agreement.
Okay. And did you attend the fireworks that year, if you recall?
Yes, I did.
You were there? Okay. Did you yourself observe anything untoward or unusual about the fireworks that year?
I did not.
Okay. After the fireworks, were you advised by anyone that there was any issue relating to the school roof at the senior center and YMCA that might be related to the fireworks display?
Not immediately after, no.
Do you remember when you first learned of such an issue?
I learned it just prior to a meeting that we had in early August regarding the alleged damage to the roof.
Okay. Can I offer whether or not that meeting might have been on August 12, 2019?
Yes.
Can I have exhibit I? I. Okay. Can you pop up the first paragraph? Mayor, this is exhibit I is an email from Mike Lucas to Robert Sorgai. It looks like you're copied on the email, Robert Fiala, in which, and who's Mike Lucas?
Our law director for the city of Willoughby.
Okay. And Mr. Lucas says in his letter, following up on our telephone conversation this morning regarding the damage claims for the roof on multiple buildings, which the city was apprised of at a meeting on Monday, August 12, 2019, with the school district representatives and multiple contractors. Do you see that?
Yes, I do.
Okay. Is that the meeting you were talking about?
Yes.
Okay. So you were contacted and brought to a meeting on August 12, 2019 to discuss the fireworks that had taken place, and that would have been about 6 weeks after the fireworks display?
Approximately, yes.
That's when you first learned there was some issue having to do with the roof and the fireworks?
Yes.
Okay. Tell me about that meeting. And apparently Mr. Sorgai wasn't at that particular meeting, correct?
I don't recall.
Okay. Can you tell me about the meeting of August 12, 2019 that Mr. Lucas is describing?
So Law Director Lucas and myself attended the meeting. The school superintendent was there. Representatives from AECom, who are the construction manager at risk, were there. Representatives of the roofing company were there, and I'm pretty sure that the roofing company's insurance agent was at that meeting.
Okay. Do you remember who the roofing company was?
No, I don't.
Okay. All right. Was Mr. Johnston there, if you know?
I think he was there, but yes.
Oh, I'm sorry. Do you know Mr. Johnston?
I do know Mr. Johnson, yes.
Can you tell me about the meeting? Can you tell me about what went on at that meeting? What was the tenor of the meeting? What was the attitudes there? Go ahead and describe your experience at that meeting.
So it was the first time that we, or at least I, had a full knowledge of the extent of the alleged damage to the roof. And this is some 4 or so weeks after the event itself. I was a little surprised at the superintendent's aggressiveness about it. It was almost accusatory towards the city. And so from that meeting, then we said, in order to understand what fully happened, let's schedule a meeting, go up there, take a walk on the roof, and see and understand this extent of the damage.
Did you feel that the city was somehow being blamed for whatever had occurred?
Superintendent was looking right at me when he was talking about this.
Had they discussed anything that they intended to do with respect to the condition of the roof by then?
I don't recall any of that, no.
Do you know whether they had made any decisions to replace the roof by then?
I don't know if a decision was made, but the meeting was uncomfortable for me.
Okay. So then a decision was made to reconvene a meeting later on?
Yes.
And tell me about that. I mean, were you to bring anybody with you in particular, or?
I took the subsequent meeting to be just a time to go up on that roof, assess, see the damage for ourselves, and then try to find a solution to it. At that point, I thought that repair was on the table. However, I would like to say, though, I do think that replacement was mentioned at the meeting, the earlier meeting on the 12th. A roof replacing the roof, yes.
Somebody was suggesting that the roof needed to be replaced on August 12th?
I believe so, yes.
And that's before you had gotten an opportunity to see the roof?
That's correct.
And that's before Mr. Sorgai of American Fireworks had opportunity to see the roof?
To my knowledge, yes.
All right. And so what did you believe that follow-up meeting on August 20th was supposed to be about?
Again, just to assess conditions, to verify to what extent the roof had to be repaired or replaced.
Okay. Did you think that further investigation needed to be done before a fix needed to be suggested?
That's the prudent course of action, is assess the roof condition, determine if it can be repaired or if it has to be replaced, and then usually an agreement occurs between all the parties to move forward.
Okay. And in your professional career, had you ever assessed, for instance, damage to a TPO and made an assessment as to whether that TPO roof needed to be repaired or replaced?
Yes.
Okay. So it's a process, is it not?
Yes.
Okay. And describe that process to me. Like, what should happen in order for a decision as to whether repair or replace a TPO roof? What should take place?
In my opinion, the conversation this conversation specifically should have involved AECom, the CMR, the roofing contractor, the roofing manufacturer, the owner, of course, owners in this case, and the design professionals to assess extent and solutions.
Should testing be done?
Yes, yes.
Okay. In a situation like this, where it's alleged that the roof was damaged by burning embers from fireworks, should an analysis be done as to the burn damage to see what potentially could have caused it or how severe it was?
I think it should have. I think you could have easily identified those smudges which are non-consequential and those that are questionable, and those that are questionable should have been tested further.
Okay. And so the inspection did take place then on August 20th, is that correct?
Yes.
Okay, let's go to Jay, Steve. And let's see who's there. Again, I know we've seen this a lot. All right, so the list of attendees includes some people from AOCOM, Brandon Paul, Commercial Roofing, Fred Day, the JM rep, and Bill Runyon, the JM rep, Travelers Insurance personnel. You're there, Judine Banker from the city is there, we heard her testimony. And Roberto Sorgai's there, is that correct?
Mm-hmm. Yes.
Okay. So were you given a tour of the top of the roof, or what? Describe to the jury what took place at that meeting.
So we visited all the roofs that were in question as to where the debris had landed.
Just for assistance for the jury, there's a diagram of the rooftop to your right. If you wouldn't mind pointing out where the areas that you yourself inspected that
Sure.
day, if you're able to.
That's the YMCA, our senior center, is another low roof of the high school.
Okay, can you observe, or can you describe for the jury what you observed?
This was several weeks after the event. There were smudges, observable smudges on that roof. To the extent of those smudges being possible roof damage were very, very minimal. What I observed were more construction defects on the roof than I did damage related to fireworks.
No, okay, let's get to that for a minute, but I want to focus on what you saw and what was being represented to you as damages caused by fireworks. Can you describe what you saw? Did you see burning, charred, ash, burned up roof?
No, the roof was clear at that point, so all you could see are small if you will, smudges or dots on the roof. And at that point, the question is, have any of those damaged the surface membrane?
And what, did you do anything to determine yourself whether you had seen any of these?
No.
Okay. Did you see anybody else doing any testing to determine that?
Yes, Mr. Sorgi was actually seeing if he could wipe some of those off using bleach to determine if it was just a smudge, a dirt spot.
And you watched him do this?
Yes.
And what was the result of his efforts?
In most of the efforts, the spots came off. And if there, spots came off.
Did you ask somebody to show you evidence of burning of the roof or something burned through the roof?
No, I did not. I was there as an observer, so I was just seeing how the contractor and the,
Did anybody specifically identify a burn hole through and through the roof?
no, nobody.
Okay. Did you see anybody collecting any evidence or samples of burnt roof TPA materials?
No,
To your knowledge, were any such burn samples obtained and retained?
to my knowledge, no testing was done that I'm aware of.
You've never seen any sample burn TPO lining?
No,
Would a good investigation, in your estimate, of whether this roof could be repaired or replaced include a sample of burnt membrane?
Okay. Overruled.
yes, I would expect the testing should have been done.
Did you, were you made aware that the decision is to replace or repair the roof had already been made by the time you went to see the roof on the 20th?
No, I was not made aware of it.
Were you aware now that when you went on August 20th, the decision to replace the roof had already been made?
Yes.
Do you think that, from your observation, sufficient investigation had been conducted involving the relevant parties up until that point to sufficiently warrant a decision to replace the roof?
Not at the time of my observation. It was surprising that the decision had been made without further investigation.
Okay. When you were there on August 20th, did you see a roof condition damage from fireworks that, in your opinion, in your experience as an architect, warranted a replacement of that roof?
No.
Okay. Did you observe anything else about the condition of the installation of that roof?
Attendant to the fireworks or
No.
anything in
Anything.
general? In general, I was a little surprised at the workmanship, quite frankly.
Okay. And did you do anything to memorialize or record any of your observations?
I took pictures of existing conditions, non-fireworks related, just construction conditions as of that moment.
Okay. Let's have Exhibit K. Mr. Fiala, do you recognize a document that's marked as Exhibit K?
Yes.
And is this, what is this? Is this a report?
This is a report that I completed, and I'm gonna, if you don't mind, I'm gonna look it up on my phone
No,
so I can see it.
I can give it to you. Let me do that.
Yeah, thank you,
In fact, here it is, right in front of me.
thank you. So, this is my report dated October 11th, 2023, giving my opinions as to the events of July 4th and subsequent events.
Okay, this is an opinion, your opinion on what you observed on that August 20th, 2019 investigation on the roof.
Yes.
Correct? Okay, and looks like you summarized your observations on page 2 of that report.
Yes.
Pre-July 4th roof. Could you go ahead and read the first couple of sentences of your report?
And you're on page 2?
Yeah.
And this is after the pre-July?
Yes.
Okay. You want me to read this?
Yes.
Okay, so I visited the high school YMCA and senior center roofs on August 20th, 2019 to determine the extent of the alleged damage caused by the July 4th, 2019 fireworks display. At this time, I noticed the poor quality of the roof installation in general and unacceptable roof maintenance during construction.
Hey, let me stop you there. I'm going to have Steve pull up your photographs. Can you put up photographs 1 and 2? Go ahead, Mayor. Then you refer to photographs 1 and 2.
Yes, and Exhibit 1 shown there actually shows a seam directly below condensate relief. They should have had a splash block or some way, a deterrent to let water drip directly on a seam like that.
Okay.
And Exhibit 2 shows water ponding in the corner near the curb of that HVAC unit, showing the lack of positive drainage and a condensate drain functions quite a bit during the course of a year. This is not sporadic rain. This is a constant dripping through all the warm months.
Oh, from that equipment?
Yes.
And is there any hazards associated with ponding water freezing?
Yes, on any roof, ponding water is not acceptable.
And what's the hazard associated with it?
Damage to the roof membrane and eventually a roof leak.
Okay. All right, let's continue. If you want to look at Exhibit 4. You observed Exhibit 4 when you were
Yes.
up there? And you can read with your report if you want.
Well, I can tell you in general, the Exhibit 4 indicates poor quality workmanship. This is a coping. It's the termination of the roof. And it's important because it's where the membrane ends, and it's a cap that kind of holds everything in place between the vertical wall and the horizontal roofing membrane. In this case, you can see it has been, the coping has been cut and then overscrewed, first of all. You can actually see silicone sealant escaping it. They're trying to, correct the deficiency by using silicone sealing. And then on top of that, there's even a crimp on the left-hand side of the seam where they were forcing the coping to fit onto the roof, onto the parapet.
Okay. Is this a leak risk here?
Yes.
Okay. Let's look at Exhibit 6 then. Well, I'm sorry. Let's look at Exhibit 3. What does Exhibit 3 depict?
Exhibit 3, this is just one picture of debris that's on the roof. In this case, they're stones. This occurred quite frequently in the roof as I saw it. And the obvious problem with this is somebody steps on that, a TPM or TPO or TPM roof is essentially a membrane. So anything that has sharpness associated with it that has an impact, if you step on it, that could puncture a roof and that could cause a leak.
Okay.
And it should have been cleaned off during construction. You shouldn't be leaving that debris on a roof.
And you saw more instances of this than is depicted in Exhibit 3?
Yes.
Okay. Let's look at Exhibit 5.
Exhibit 5 shows a curb or a coping again. In this case, you could see the seam, how poorly it was welded together. There's a patch over it on the vertical surface, and then you see discoloration below it, which indicates there's water ponding in that area.
Okay. Is that a risk of a leak?
Yes.
And then Exhibit 6?
Exhibit 6, this shows one of the fastener plates, what I think is the underlayment, and somehow it's been abraded so that what you're seeing is that intermediate membrane, that's the if you will, the reinforcing membrane between the two things of plastic, two layers of plastic, but it's actually worn at the edge. This would be a leak, eventually become a leak.
Okay. Let's look at Exhibit 7. What do you see? What are you observing here in Exhibit 7?
Again, you see extensive debris along the edge of the parapet wall. And then at the where the half circle exists, you'll see multiple patches and then some other debris right there too, which means that at that corner, this apparently is where there's a corner that in my opinion, the membrane has not been properly affixed and contoured to the corner.
Okay. You conveyed in your report, you made a comment in your report about you're surprised that these defects weren't picked up by the manufacturer. Can we have page 2 again, Steve, at the bottom? Can you read what you wrote at the bottom of page 2 of the report?
It's astonishing that Bill Runyon, during his visit on the same date, missed these obvious and serious roof installation deficiencies in his report, dated the same date as my photos. The photos from Runyon's August 20th, 2019 report indicate damage by others in photos 1, 9, 110. Those were, I believe, from his exhibit.
All right. Did you get the impression that Mr. Runyon was focused more on what he believed to be firework damage than
There's no question in my mind he was more focused on that.
Okay. If we look at page 4, you were involved in, or at least observing, discussions between the various contractors in terms of what needed to be done, whether this roof could be repaired or replaced. And let's highlight that paragraph as mentioned above. We're going to go ahead and read, or read your report where you describe these discussions?
Objection, Your Honor.
Just ask, I don't want him reading the thing.
Okay.
Your Honor, may we approach?
Yeah.
Thank you.
We're gonna do this a little better, Mayor. In your report, you say, given the scale and cost of the alleged fireworks damage, a thorough roof analysis should have been completed by Johns Manville and the installing contractor. What did you mean by that?
That it gets back to our earlier conversation that there should have been a much more extensive, there should have been much more extensive research and testing done prior to making the decision to spend over $1 million on a replaced roof.
You make the statement, the contractor suggests that a total membrane replacement must be authorized immediately due to material delivery concerns and potential weather issues. What did you mean by that?
What I think the intent of that comment was from Runyon or the manufacturer was that there was some sense of urgency to get that roof replaced.
Okay. You say here, actually, there's an apparent tactic to create a fictitious crisis and make an ill-advised decision costing $1 million. What did you mean by that?
I think this sense of urgency was created. You can install roofs any time of the year as long as the weather cooperates. To my knowledge, there are no material delivery issues at this point in time. To stand back for a month or two to do an analysis would have been the better course of action than rushing to judgment.
Okay. And then you indicate further down, I did not observe areas of possible repairs required due to the alleged damage of fireworks display that could not have been suitably corrected by patching. Do you believe that?
Yes, I do.
Okay. Do you believe patching of TPO roofs can be an effective fix and repair?
It's done all the time, and it's warrantable.
Okay. When you say it's warrantable, as part of your job, you would be involved in negotiating with manufacturers and contractors in assessing the quality of the installation such that you were involved in getting the warranty issued. Is that right?
Yes.
And during that time frame, there's always discussions with the manufacturer and the installer about things that need to be done to get the warranty, right?
Yes, that's correct.
Is it appropriate, and sometimes, that certain areas of roof can be repaired and patched in order to get a warranty issued?
Yes.
Mayor Fiala, have all your opinions today been to a reasonable degree of architectural certainty?
Yes.
Are you being paid to be here, sir?
No, I'm not.
Okay. You are the first expert in this case not being paid to be here. Thank you very much, Mayor Fiala.
Mr. May?
Thank you, Your Honor. Good afternoon again, Mayor. Nice to see you again.
Good afternoon.
When you went out for that August 20th inspection, you said that after your meeting with Mr. Johnson, in which he appeared to have some sense of urgency, you were acting then in your capacity as mayor of the city of Willoughby, is
Yes,
that correct?
that's correct.
All right, you were not a retained forensic architect, is that correct?
That's correct.
And when did you retire from architecture?
You're an architect for life, much like a doctor, so not
Sure.
retired.
When's the last time you practiced architecture?
2017.
Okay. All right, so then you didn't conduct a forensic architectural investigation on the roof, did you?
I did not know.
That wasn't your purpose in being out there, isn't that correct?
No,
Is that correct?
that is correct, yes, I'm sorry.
Okay. You were there to meet with the superintendent and, like you said, try to figure out some kind of solution, is that right?
Yes,
Okay, and as the mayor, in a sense, you were directly involved with this because the firework display was actually sponsored by the city. Is that right?
that is correct, yes.
But you yourself were not directly involved with the planning of the firework display itself. That was in the, under Judine Banker, is that correct? Who is now Judine Keller?
Judine Banker and our Chief Fire Prevention official, Mike Kokab.
Okay, but in your involvement, you weren't directly involved?
That's correct, yes.
Okay, and, but you did sign the contract with,
Yes, that's
with
correct.
American Fireworks, is that correct?
Yes.
Is there a book in there, plaintiff's exhibits, and I'll step up and hand you this if not.
Where would I find it?
It should be a giant book like this one here, but I think I
It
could.
may be behind
Ah,
you.
okay.
Okay.
Which one
I
of the
don't mind
giant
bringing,
books?
you can have this one, Your Honor, may I approach?
Yeah.
Thank you.
Thank you.
Just handing you, fortunately, it's Exhibit 1 here, so that's all we have to look at. That would be the contract, I believe. Is that what you recall being the contract there?
Yes, that's correct.
And that has your signature on page 2, is that correct?
Yes, yes.
Did you read that contract?
Yes.
Sorry, I'm looking for a copy of it right now. Do you mind if I step up and
Yeah.
just look at it with you there? All right.
Mr. Mayor, I have a copy here if you want.
Thank you. That'll be helpful. Thank you. Okay, Mayor Fiala. I think I have to look at my copy. I'm sorry. Did you read in the contract here where it says that the display company shall be responsible for an inspection of the display area and fallout zone for debris and other items related to the fireworks display? Did you know that was in there?
Yes.
Okay. And how would you interpret that promise there?
That was to me, represents a dialogue between the city representatives of the city of Willoughby and the fireworks contractor for the execution of the fireworks display.
So American Fireworks should have inspected the area for fallout debris after the show?
I can't answer that question. I'm sorry. Not first time I've seen the contract since 2019.
Do you know whether American Fireworks inspected the fallout area after the show in 2019?
I do not know that.
Do you know whether American Fireworks had ever been on the roof prior to being there with you on August 20th of 2019?
After subsequent to the event, the fireworks event?
Correct. That subsequent to the fireworks event, yes.
I learned of it, yes, after the event.
That was the first time they had been up there, to your knowledge? August 20th, 2019?
That's the first time that I was up there. I don't know if any of the representatives of the city were up there between those dates, July 4th and August 12th.
When you went up on the roof on August 20th, 2009, you didn't take any of your own pictures, is that true?
I did take pictures, yes.
On,
Yes.
okay. Do you recall deposition if you took picture on your trip?
Yes, in the first question, I said I did not take pictures. The second deposition, I corrected my,
Okay, so how many pictures
maybe 6 or 8 in my report.
of the photos?
Yes.
Photograph any of you indicated you saw 10 court marks, correct?
I said about 10 dots on this roof. Clear, the photos that I put aren't to indicate fireworks damage. Those photos were meant to indicate the extent of the quality of the workmanship, exclusive of the damage of the fireworks.
So, but when you went up to look at the damage that Mr. Johnson was upset about, you went and you didn't take pictures of the damage. You took pictures of escutcheon plates and.
Right, that is correct.
But you have no pictures of what you identified as you said 10 marks. Is that right?
Yes, approximately. I only saw, as we walked around, we didn't look at every dot or spot on the roof. We just in general said, here's some, there's one here, there's one there. We stopped maybe at 10.
And you didn't examine any of those dots, did you?
Only with everyone present looking at them, but I did not do an intensive evaluation of the roof, or the roofing membrane.
So you don't know whether or not those dots that you're describing were penetrations in the TPO membrane or not. Isn't that true?
That's correct.
For all you know, those are 10 holes that were allowing water to flow into the roof system. Isn't that true?
Yes.
And so you didn't examine them and you didn't take pictures of them at that point in time. With respect to, you didn't take any video up there, correct?
That's correct.
You've referenced that you believe that there wasn't adequate testing prior to the determination to replace the membrane. You didn't request any testing, did you?
Not to my knowledge.
Why didn't you request testing at that time?
At this point, I believe this was an issue between the installing contractor and Johns Mansville, and we were just standing by as an observer of the process.
Okay, so you're not involved.
Well, not involved. I mean, I think it really becomes a roofing contractor, an owner, the design professional, and Johns Mansville.
Agreed. And do you know, in point of fact, that that's exactly how it was handled?
I do not know that, no.
Okay. You didn't keep your finger on the pulse, so to speak, as things progressed down the road, and there was a representative. The contractors, the subcontractor who installed the roof was involved. Do you know who that was?
I don't recall the name, no.
Commercial Roofing
Commercial
Coating
Roofing, yeah.
Systems, the same contractor that worked for the building contractor.
Right.
They would be the right person to be involved, according to you, correct?
I'm sorry, can you ask that question again?
They would be one of the parties you would want involved.
Yeah, but I wouldn't have them tested. They're the installing contractor.
I agree. And then the independent roofers
Yes.
came in. There was an independent roofing consultant named Ken Hansen, came in for travelers from Tennessee, because travelers wanted to make sure about the damage, and that would be appropriate, wouldn't it?
Yes, again, they're an interested party. I'm not, any agent of the insurance company or the contractors, I would feel uncomfortable about, myself personally.
Well, Mr. Hansen is an independent construction consultant. Would that make you more comfortable because he doesn't work for travelers?
Well, you just said he was an agent for travelers, I think, didn't you?
If I said that, it was mistaken.
Okay.
He's an independent roof construction consultant.
I guess my
hired by
question to you,
travelers.
it should be an independent, an owner actually should be hiring that person independent of everybody to get a clear assessment as to, so that there's no conflicts in play.
And I would agree with that. And the owner, Taylor Shaw was also hired in this case as an independent consultant. Did you know that?
No, I did not.
Okay. Did you know that there was an estimate produced for the roof to address the firework damage after evaluation that was in excess of $2 million.
I did not see that estimate, no.
And you said Travelers is an interested party, but really Travelers' interest, if they were going to have an interest other than protecting their insured, it would be to protect them, to not overpay the claim, right?
Allegedly,
And you know enough about insurance companies to know that they don't want to overpay claims.
that's correct.
Okay, thank you. Let's bring up we have your report up here. So, and Mr. Fogarty asked you about your report. And this report is addressed to Attorney Edmund Z. Jaber. Do you know who that is?
Come on up here.
We could scroll down, please, on the report. Scrolling down here, Mayor Fiala, you list the items that you did examine in your investigation, correct?
Yes,
Okay, and just reiterating, but the folks that I had mentioned there, whose reports you don't have, are Adam Searcy, Kent Hansen, Brandon Paul, correct?
that's correct.
All right. And look, just checking the list here, you have item J, liability claims status report dated February.
Objection.
Come on up. Objection sustained.
Do you know the burning temperature of TPO?
No, I do not.
Do you have any reason to believe it's anything above 300 degrees?
That it's above 300
Do
degrees?
you
I don't know.
Okay. You indicated there was a sense, you felt like there was a rush, but we talked about it and various reports were issued. You understand that the school had to open up for students coming up in the coming year. You understood that, correct?
Yes. Mm-hmm.
Do you know what would have happened if those students wouldn't be able to go to school in that building?
It would be an inconvenience, but in my experience putting roofs on or designing roofs on buildings, there are workarounds. You can do it.
But it's not the best.
It's not the best.
Okay, thank you. Nothing further.
Redirect.
Very briefly, Your Honor.
Mr. Fiala, sticking with that last point that Mr. Doug made, I don't want you to have the wrong impression. School opened on time that year, did it not?
I think it did, yes.
Okay.
Mhm.
And the roof was ultimately replaced, but that work wasn't finished until April of the following year. Were you aware of that?
I recall that, yes. I know it was later in the spring, the following spring.
So this issue with the roof repair or replaced had absolutely nothing to do with whether the school was gonna open on time. You agree with me?
If they work through the winter, apparently not, no.
Okay, just so we're clear, you heard the word Ken Hansen, I heard you testify that you thought the roof should be tested by independent sources, I agree with, and Ken Hansen was actually hired by Travelers, were you aware of that?
I suspected that, yes.
And this Taylor Shaw was actually hired by the roofing contractor, right?
That I didn't know.
Okay, but these are, neither of these people, do you think would be appropriate sources of the people to test the roof solution, correct?
Yes, I agree with that. They should not have been there. I don't believe they're fully independent.
Thank you very much. Thank you for your time.
Any recross?
Just one, Your Honor. I mean, your view, Mayor Fowler, who would be fully independent?
I would find that there's multiple roofing inspectors or people that do these kinds of tests. I would have found somebody independently of the selection should have been made by somebody other than the roofing contractor, the construction manager, or the roofing manufacturer, the roofing installer, or the contractor.
But you didn't make a request of any kind, knowing that there was damage, knowing that they were going forward with the replacement. In fact, the city kept tabs on that, didn't they?
Yes, we watched it.
But at no point did you ask for any independent evaluation, did you?
It was it's not our, well, the one building was our building, but it's not, this issue is a construction issue. We held no contracts with anybody involved in this project, so we had no contractual authority to authorize anything.
Well, you're a partner in the development company that designed the building, aren't you?
At that time, I was not.
No, nothing further, Your Honor, thank you.
Nothing further,
All
Your
right,
Honor.
you may step down. Does have any other witnesses?
No, Your Honor, at this time, subject to the admission of exhibits, defense rests.
All right, is there any rebuttal evidence?
No rebuttal evidence, Your Honor.
All right, ladies and gentlemen, the defense is rested. There is no rebuttal evidence. That means you've received all the evidence you're going to receive in this case. The next step in this case is going to be the jury instructions and closing arguments of counsel. That's not happening today, so you're going to be released for this evening. Remember not to discuss the case among yourselves or with anybody else. Don't try to get any information from any other source, and do not come to any conclusion until you are back in the jury room to deliberate. Please be back at 8:25. We'll get started at 8:30 tomorrow. Have a good evening.
All right.
All right, anything else on the record?
No, Your Honor.
All right, as to exhibits,
I'm
sit
sorry.
down.
Oh, yes.
Have a seat.
Move to admit, Your Honor, exhibits A through OO as submitted in our exhibit binder, that all of which have been identified at one point or another through witness testimony.
We have an objection to Exhibit 11. It's a letter from me. It's a demand letter. We've talked about it in the objection. I think that should come.
11?
Aye.
Oh, yeah, aye.
Aye. Is that
Aye,
right?
aye, sure.
No, it's not.
Not
You
aye,
did-
aye.
I'm not sure whether, I'm looking here. There's a letter. You've got it.
I know what he's talking about, Your Honor. I'll withdraw it.
Can I have a second on paging through the rest of it?
So now I can't find it.
That's our only objection, Your Honor. That can come out,
It's Exhibit L.
L.
Exhibit L, it's Mike Lucas's letter to Mr. Sorgai, enclosing Mr. May's demand for $1.2 million. I will withdraw that exhibit. So let me, I'm gonna have, this exhibit binder, Your Honor, will be the one that I'm gonna give to you to give to the jury, and I will remove it right now.
Dennis, I had ripped some stuff out of that binder, just to let you know.
Okay.
We'll bring our books back, if that's okay, tomorrow, Your Honor. when we-
Yeah.
Yeah, we'll do that. I'll make sure I have the right one, but I'll withdraw that exhibit, Your Honor.
All right, anything else?
Not for the plans, Your Honor.
All right, I'm going to give you a copy of the redrafted jury instructions. Take a
send it to you, thanks. We have,
Responding at Superior, we don't need anymore,
yeah,
because we stipulate to dismissing Eric.
okay.
And then I'm good with everything else, Your Honor.
All right, on page 3, the bottom of 3, expert testimony. There were no hypotheticals asked.
That's
So-
true.
So I'm gonna take
Not of
that,
experts, right?
huh?
Not of experts, you're right, Your Honor.
So I'm gonna take that paragraph out, continuing on 4. And do we have something in there on redaction?
Yeah, it's under, evidence, I think. The evidence includes. It would be the last paragraph.
Okay, yeah, bottom of page 2, redacted, they're just noting that the redactions, they're not to take anything from that.
Yes, thank you, Your Honor, I appreciate that.
Anything else
No, Nicole, will you email them to us
tonight?
Okay.
Thank you.
All right, so why don't you guys be here at 8 in case there's any last minute things that need to be done? All right,
Thanks, Judge.
and then
Thanks,
as you may have noted, I go to the middle of page 7 before you guys argue, then I do the rest of them at the end, okay?
Yeah.
I'm sorry, I did not notice that.
6.5 pages of instructions, then you guys argue, and then I give the remaining 3 pages.
Okay,
So-
good. Is it okay if I have when we're arguing you've given them the instructions?
They're gonna, what, go ahead.
Hang on, let me get this straight. You're gonna read them the first 6 pages, and then we argue?
Yeah,
Okay, so can we argue about the instructions to the jury?
yeah, as long as you're accurate.
Well, I'm gonna have my guy, assuming he can get his thing working, I'm gonna have them up on the screen while I argue.
You can do that as long as that's what they are.
Okay, thank you.
They're also gonna have a copy to follow along when I read, just so you know.
Okay, thank you, Your Honor. Thank you, Nicole.
All right, anything else?
Your Honor, you're gonna, I guess we'll do standard interrogatories.
Well, I was thinking about that. There's gonna be 3 verdict forms, 1 for each, and then an interrogatory for the standard of care for just negligence, if they find that, and then was it the proximate cause? And if they're yes, then it'll fill in the amount on that, and then we'll do the same thing for the other 2 claims.
That's what I was thinking.
So-
I think I already submitted a verdict.
Well, we'll send you that. We'll get that to you
We'll
tonight,
submit
but
it.
essentially, it's gonna be 6 interrogatories, 2 for each of the
Right.
claims, and then 3 verdict forms,
That answers my question, thank you, Your Honor.
okay?
Thank you.
All right, see you tomorrow.
Thank you.